49.
What? Item number?
49.
You want to withdraw? It has been complied with.
No, no. The SPCL against the order was passed, it was taken over by state government.
Mr. S.K. Kejriwal, the learned counsel appearing on behalf of the petitioner submits that what has happened? What has happened?
The order was against the SPCL, Gujarat Paper Board Trustee.
Submits that as the order which was passed by this court was against Hindustan Paper Corporation Limited, which is under liquidation. The instant contempt proceeding, the order had become redundant, for which he would not like to press the instant contempt proceedings. So, taking into account the above, the instant contempt proceeding stands dropped. Hmm. 29. Yes. What is that matter about?
I would like to take this regard to limiting the budgetary support to industry already that were having the benefit to a maximum period of 5 years. That regulation and that issue is hearing is continuing before court number 20 for honorable and it is listed to take.
You want an adjournment?
That is a part.
So, is this matter parted?
No, this may be taken up because the issue is not the same.
How can I take up the matter before another court which is parted?
No.
Okay, at the request of the learned counsel for the petition, matter stands adjourned to be listed after 6 weeks.
Again, number 6.
6. Mr. R.K. Talukdar, the learned counsel appearing on behalf of the petitioner, submits that the writ petition has become infructuous, for which he would not like to press the instant writ petition. Accordingly, the writ petition stands closed on withdrawal. Interim order, if any, stands vacated.
Item number 34. In this case, I will give you the marking.
Huh?
34 item.
Yes.
This I engage with the marking.
So, there's no name here. What is the matter about?
Regarding the termination of contract
So,
by the Irish. That is.
huh?
There are
No objection. At the request of the learned counsel for the petitioner, matter stands adjourned to be listed after 6 weeks. Yes.
Item number 12.
It will be influxus going. A which was and accordingly withdrawn stands closed. Abar to the order. This is 6 on issue.
and with the consent of the petitioner, affidavit related by the higher authority of the person. Date of the written application.
Why? 2015 matter. We'll see why the matter has come up for orders. No adjournments.
Affidavit related
Huh?
by the higher.
So, it's a 2015 matter. We'll see why the matter has come. 50? Yes. Why the matter has come up for orders? So we'll pass the appropriate orders directing the state to file the affidavit. Huh? Who is appearing for response number 6? No adjournments. 2018, 5 years have gone. Why it has come for orders? We'll see. Don't mention matters of orders. Next.
Should I like to mention item number 6? That we're playing for withdrawal, your lordship.
Okay, withdraw. Go you. Huh? 26, withdraw. What's your name?
Pastor Das.
Hmm?
BJ Das, Pastor.
BJ Das. Your name is not there?
It's your lordship.
Then?
On behalf of H. Rahman.
Huh?
On behalf of H. Rahman.
26.
26.
There is no H, Sharma.
P. Agarwal.
P. Agarwal. And let anybody of these people be present. Otherwise, we'll wait when the matter comes. Yeah. Hmm. Let the matter reach. Otherwise, this court is not going to do. You are Mr. Asitia? No, 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 no. Mr. Counsel, why are you not understanding? How many years of practice you have? Now, how many years of practice? 5 years. Now tell me one thing. No, just tell me. I put your name. You have not signed the Wakalatnama. If you have not signed the Wakalatnama, tomorrow this person comes over and says that this has happened. Then what are you going to do? You will be reported to the Bar Council. Then don't mention if you are not there in the list. File a Wakalatnama, then we'll consider whatever may be. Otherwise, we'll take up the matter. You can't withdraw in this manner. Because if I allow you to withdraw, his rights is affected. In one of your matters, just for example, one of your matters, some lawyer comes out here and I give them the adjournment and I allow them to withdraw it. What is the consequences? Then don't mention if you are not there for withdrawal.
Promotion.
Why is it after 2 years the matter has come up for motion? What is the matter about? Motor accident. Where is it? Where is your representation? When did a person die? 19, due to road accident. Hello. Okay, disposed. It is disposed for you, 15/11/2014 or 3 months.
Number 2.
Matter relates to what? Relates to what? Mr. Protester, your petition has 86 pages. What do you want? No, declaring the FIR which have been registered under so under 406 and consequent investigation to be not maintainable for want of jurisdiction under 291. Navin Chandra Mizitia. You are challenging FIR. Huh? Okay, let us see the FIR. Where is it? Annexure? Okay. Yes. Mr. Prakash, this court is not doubting that. That this court has the jurisdiction. Because here this person resides at, the complainant resides out here. So there is no quarrel with that. 226(2) is applicable. Now the question therefore is out here. Let us see what is the contents of the FIR. Yes, please.
I request you. Complaint also against Congress. I request you. That I am Dinesh Singh Chauhan. All of Congress also, resident of Congress also, I have set up loan making factory. Coming number 1. Class number 2. The meaning of clear number 5. Raw materials for making zone. And some for account. The person name is issue only Kavita. Here the value Guwahati contacted me. I have verified. And asked me to take the raw materials for making to policy. Mobile with transfer of after taking to the team. Many times I went to Guwahati to make money. And after talking to me about the raw materials, returned to Gurgaon after 2 days. After that, the phone of say Kavita came to me and said that if I go to the Kira, in his account, then he will stand raw materials for making things to Gurgaon. After this, I visited the Kira on 26 to 2020 and 1 lakh rupees. Then on 29 to 2020 in the economic account. Number also State Bank of India, located in Kailash Road. After receiving the state amount, the state economic committee assured me that he would stand.
So what is your case?
My case is that I am a transporter. I am a commissioner. I am supposed to arrange the truck for transport the goods. For getting the goods by exit number 1 to exit number 5. I may not end with that. Subsequently, there was a dispute between exit number 1 and exit number 5. And I was in that. What is my role in making the agreement? I am simply a transporter. I have a road agency. I am supposed to arrange the card. I have item back. To facilitate me our transporter to transport.
So let it be investigated upon. What is wrong?
Whether police has got anything.
Huh?
Police have got anything.
Whether Gurgaon police has jurisdiction or not, you go before the Delhi High Court or Punjab and Haryana High Court for that. Whether that. No. This court is not going to touch on that. No.
Party or wholly arises beyond the jurisdiction of that particular police station. Then the court shall have the.
No.
Because the corporation arises.
No, mister. No.
Corporation arose not within the jurisdiction of Guardian, wholly and part. It was instead beyond the state jurisdiction of Guardian. If the corporation arose partner wholly, this court has completely. There is a law.
I think you better test this law again in Supreme Court when I dismiss your petition. Yes. No, I'm dismissing it right now. I'm dismissing it. I don't find it. The case is made out. No. No, Mr. Prakash, kindly appreciate one thing. This is a case where there is a complaint being filed to the effect that you, along with the other person, have cheated. Now, whether cheating has happened or not, that is a case because there is an allegation to the effect that both of you have taken the money of 5,90,000 and accordingly have not sent it out there, and both of you have been involved. Now it is for the police to investigate. Why should this court at all interfere? Are you saying that this FIR does not make out any cause of action in any case? Then that is the case. No. Okay. Heard, Mr. No. I am dismissing it. You go to division bench wherever it is. No. No. Sorry. No, Mr. Prakash, enough. Sorry.
jurisdiction.
No, I am saying this court has jurisdiction. I'm not saying the court doesn't have the jurisdiction. If it was a case, but when the FIR, the court having a jurisdiction can only adjudicate as to whether the complaint makes out the case. That's all.
Now, then, okay, we'll examine whether any final case is made out. Therefore, if for one-
Are you saying from the complaint, no case is made out?
Then, no, then I have a right to address the court on this.
You have addressed. What else is required?
Now, whether any final case is made out or not.
Are you saying from that FIR, no case is made out?
Exactly, so far as me is concerned.
No, not for you. Can the FIR be partly?
Yes, yes,
Show me that. Show me that.
then I will not address the court on, it's a matter of. I think-
No. Today, this matter is there. Kindly show me that the FIR can be partly quashed. Show me.
I don't know, at the moment, I am not, I'm not.
A complaint may be in a complaint case against a person, you can very well do it. But can a FIR be partly quashed when it is a question of investigation?
But a person he cannot be said to happen.
Mr. Purkasthar, you make these submissions before the division bench. I am not interested to this. But
Give me a minute.
no, nothing doing.
Sometime,
No,
otherwise, no,
Mr. Purkasthar. Sorry.
otherwise, there is still that's on my part.
So what?
Because board has initiated, I don't know, already question whether this board has got jurisdiction or not. And that one matter was hard. And so far the merit part is concerned, that was not even acknowledged before. Now, what is the time to examine that particular point? Therefore, I have the impression that authority board is here with the question of jurisdiction. And subsequently.
What is there? No, Mr. Purkasthar, I don't know. Am I not being able to convey it to you? Here is a case, this court is not saying that this court doesn't have the jurisdiction. But whether the case has been made out or not in the complaint, that is the only thing which needs to be looked into. When it is a case of investigation which is to be done as to whether you come within it or not, that will be done by the authorities.
Unless and until I use the sanction, the exam.
Sorry, the instant repetition has been filed.
I have the impression.
You can take all these grounds out there in the division bench. Has been filed challenging the FIR
I don't think, my lord, this is-
dated
I don't.
FIR,
do not understand.
FIR dated. FIR dated. The FIR dated 28/6/2021. Filed by the respondent number 5. Before, lodged by the respondent number 5 before the officer in charge of Gurgaon for the officer in charge of Sector 10A police station at Gurgaon, Gurugram. This court have duly perused the translated copy of the FIR at page which have been enclosed as Annexure 3 at page 97 and 98 of the writ petition. From a perusal of the repetition, said FIR, it reveals that the respondent number 5 claims that he has a broom making factory at Goli number 1, Vikas Nagar, Gurugram, and carries on the business in the name and style of DS Enterprise. It has been alleged in the FIR that a person named Ritu Moni Kolita had contacted the respondent number 5 and asked him to take raw materials for making broom from him. The respondent number 5 thereupon went to Jagirod to meet the said Ritu Moni Kolita. It has been further alleged that the said Ritu Moni Kolita came to the respondent number 5 and informed the respondent number 5 that if he puts rupees 3 lakhs in his account, in the account of Sri Ritu Moni Kolita, the said person would send the raw materials for making broom to Gurugram. It has been further alleged that the respondent number 5 deposited rupees 2 lakhs on 26/2/2020 and rupees 1 lakh on 29/2/2020 in Ritu Moni Kolita, in the said Ritu Moni Kolita's bank account number 203383400324, located at VIP Road. It has been further alleged that the said Ritu Moni Kolita assured the respondent number 5 that he would send the entire carriage to Gurgaon within 2 days. Within 2 days. After 2 days. It has been further alleged in the FIR that the respondent number 5 called the same Ritu Moni Kolita and the said person informed that after 3 days the truck would be leaving, and the respondent number 5 was further asked to deposit rupees 40,000 in the account and put rupees 20,000 in the account of the transporter, that is the petitioner. The respondent number 5 further alleges in his FIR that he had deposited rupees 40,000 in the account of the said Ritu Moni Kolita and rupees 20,000 in the account number 07572020000199, having IFSC code number bearing IFSC code 0002930 of the said Assam Haryana roadways. It has been further alleged that the respondent number 5 called the said Ritu Moni Kolita, who instructed the respondent number 5 to talk to the petitioner. Further to that, it has been also alleged that the respondent number 5 had spoken to the petitioner, who informed him that another amount of rupees 2,50,000 has to be deposited in the account of Ritumoni Kolita, then the truck would come. It has been also alleged that the petitioner informed the respondent number 5 that on payment of the said amount, he guaranteed that the truck would come. Under such circumstances, the respondent number 5 deposited another amount of rupees 2,30,000 in the account of the said Ritumoni Kolita. However, as the goods were not delivered, and however, it was alleged in the FIR that the goods were not delivered, and further, the respondent number 5 was threatened by the petitioner and said Ritumoni Kolita. The said FIR was lodged, alleging that the said Ritumoni Kolita and the petitioner had cheated the respondent number 5 with an intention of harming his business and 2 others, and have also cheated with a plan of with the amount of rupees 5,90,000. The petitioner herein, the said FIR, upon being lodged before the police station, before the officer in charge of the police station, Sector 10A, Gurugram, was registered as FIR number 0427/2021. The petitioner being aggrieved at the FIR being lodged against him has approached this court by filing the present writ petition. It is the case of the petitioner that the petitioner is nowhere involved in the, as regards the allegations so made in the said FIR. Inasmuch as the petitioner had only received an amount of rupees 25,000 for transporting the goods to as much as the petitioner have only received an amount of rupees 20,000 in his account standing in the name of Assam Haryana Road Lines as advance, It is under such circumstances that the instant petition was filed for the following reliefs. Number one, a writ in the nature of certiorari and or any other appropriate writ, direction or order declaring that the impugned FIR dated 28/6/2021, which was registered under Sector 10A Police Station, Gurugram, Haryana, being PS case number 0427/2021 under Section 406 IPC, and the consequent investigation thereon to be not maintainable for want of jurisdiction in view of Article 226 of the Constitution. B, a writ in the nature of certiorari or any other writ of like nature should not be issued declaring that the impugned notice dated 31/7/2021 issued by the respondent number 4 at Guwahati under Section 41(1) of the Code of Criminal Procedure 1973 shall not be declared to be not maintainable in law for want of jurisdiction in view of Article 226 of the Constitution. C, why the FIR dated 28/6/2021 and the consequent PS case number 0427/2021 registered under Section 406 IPC by the officer in charge of Sector 10 Police Station, Gurugram, Haryana, as well as the notice dated 31/7/2021 under Section 41(1) CRPC issued by the respondent number 4 at Guwahati should not be quashed as not maintainable in law for want of jurisdiction in view of Article 226 of the Constitution. D, directing and commanding the respondent number 5 to withdraw the impugned FIR as well as the investigation made therein against the petitioner. E, as to why a writ in the nature of prohibition and or other writ, order or direction of like nature should not be issued, prohibiting or restraining or preventing the respondent numbers 1, 3, 4, 6, more particularly the respondent number 4 and 6, from conducting any further investigation against the petitioner in view of non-disclosure of any prima facie case of cognizable offense in the impugned FIR dated 28/6/2021 in view of the law laid down by the Supreme Court in the case of State of Haryana versus Bhajanlal, reported in view of the well-settled law. From a perusal of the FIR, from a perusal of the writ petition and hearing the contentions of the learned counsels for the parties for the petition, it reveals that the contentions are twofold. First, that the Gurgaon police station could not have lodged the FIR in view of the judgment of the Supreme Court in the case of Naveen Chandra N. Majithia versus the state of Maharashtra, reported in AIR 2000 SC 2966. It is also submitted. It is the second ground on which the second contentions on which the proceedings, the FIR has been impugned FIR dated 28/6/2021 has been challenged, is on the ground that no prima facie case has been made out against the petition. Next. In order to deal with the said contentions, this court finds it relevant to take note of a recent judgment of the Supreme Court in the case of Niharika Infrastructure Private Limited versus State of Maharashtra and others, reported in 2021 SCC Online SC 315. In the same judgment, at paragraph number 57, the Supreme Court, after taking into account all the judgments, right from the judgment of the Supreme Court in the right from the judgment of the Privy Council in the case of Khwaja Nazir Ahmed versus the Emperor, laid down certain principles taking into account the above. This court finds it relevant to quote, to reproduce paragraph 57 of the said judgment herein under. Next. From a perusal of the said from a perusal of the above quoted judgment, above quoted portion of the judgment in the case of Niharika Infrastructure Supra, the Supreme Court observed that the police has a statutory right and duty under the relevant provisions of the Code of Criminal Procedure 1973, contained in Chapter 14 of the Code, to investigate into cognizable offences. It was observed that the courts would not trot any investigation into cognizable offences. It was also observed that while examining an FIR/complaint, quashing of which is sought, the court cannot embark upon an inquiry as to the reliability or genuineness or otherwise of the allegations made in the FIR/the complaint. The Supreme Court further went to the extent of stating, of observing, that save in exceptional cases where non-interference would result in miscarriage of justice, the court and the judicial process should not interfere at the stage of investigation of an offense. In the backdrop of the above, let this court therefore take note of the contentions which have been raised by the petition. The first contention is so raised is that the impugned FIR dated 28/6/2021 and the registration of the said FIR, along with the consequent investigation, was not maintainable for want of jurisdiction in view of Article 2 to 6 of the Constitution. The said submission has been made, the said contention has been made on the basis of the judgment of the Supreme Court in the case of Naveen and Majithia Supra. This court have duly perused the said judgment the facts leading to the said judgment was that an FIR was lodged by a company at Shillong with the Shillong police alleging that the Mumbai company had cheated the Shillong police to the tune of ₹9 crores. As the investigation was not carried out by the police on the basis of the FIR filed by the Shillong company, a writ petition was filed before the Shillong bench of this court, as it then was, for appropriate directions. The single judge of this court, a coordinate bench of this court, of the Shillong bench of this court, passed the direction thereby directing the Shillong company, thereby directing the Meghalaya police to undertake the investigation at Mumbai. And the costs of such investigation shall be borne by the Shillong company. An appeal thereupon was filed by the state of Meghalaya, challenging the said order of the coordinate bench of this court, challenging the order of the single judge. But the said appeal was dismissed. Subsequently, the Meghalaya police took steps to investigate the matter as per the directions of the single judge, as per the directions of the order passed by the single bench of the Shillong bench, single judge of the Shillong bench. And the appellant before the Supreme Court, Mr. Naveen Chandra N. Majithia, moved the writ petition before the Supreme Court, before the Bombay High Court, for quashing of the FIR and further proceedings taken therein. The said writ petition, however, was dismissed by the Bombay High Court on the ground of jurisdiction, on the ground that Article 226 of the Constitution, on the ground that there was no jurisdiction under Article 226 to deal with an FIR registered at Shillong. The appellant, that is Mr. Naveen Chandra Majithia, thereupon filed two special leave petitions before the Supreme Court. One challenging the order of the Bombay High Court, whereby the writ petition was dismissed on the ground of jurisdiction, and the other challenging the order passed by the division bench, whereby the appeal was dismissed, challenging the order passed by the division bench of the Guwahati High Court, of this court, challenging, whereby the appeal filed by the state of Meghalaya was dismissed. It is under such circumstances, the Supreme Court observed Yes, Mr. Purkasta, which paragraph you are referring to? Navin Chandra Meditya. The Supreme Court. And of course, both the special leave to appeal were disposed of by two separate judgments by the Supreme Court. One of such judgment, on the question of the territorial jurisdiction, the judgment is reported in 2007 SCC 640. And the question, and on the ground, on the challenge made to the order passed by the, on the challenge made to the order dismissing the appeal, the writ appeal by the division bench of this court is reported in 2008 SCC 323. Mr. A.K. Purkasta, the learned counsel appearing on behalf of the petitioner, submit that the judgment which have been relied upon by the petitioner to buttress its contention is the judgment which have been reported in 2007 SCC 640. And in that regard, have referred to which paragraph? Referred to the concurring judgment. It's the concurring judgment? Huh? Refer to the concurring judgment. Refer to the opinion of Justice K.T. Thomas, of the opinion of his lordships, Justice K.T. Sharma, K.T. Thomas, as he then was. In that regard, reference was made to paragraphs 37, 38, paragraph 32, 32, 33, 35, 36. These are what has been, these are all judgment. Well, you are referring to which portion? You are not referring to other judgments. You are referring to what is given out there in the Supreme Court. What did the Supreme Court say? No, referring to others, I'm not concerned. I'm saying which paragraph the Supreme Court says that it is not maintainable. Refer to paragraph 41.
Conclusion was made in paragraph 45 and 46.
45 and 46 in the aforesaid situation. Huh?
The next question for concern, the considering the regular fact situation of the great year of due that setting aside of the.
I give you the more benefit of paragraph 43 now. Huh? We make it clear that the mere fact that the FIR was registered in a particular is not the sole criterion to decide the cause of action, isn't that?
The provision of the 43.
43. Okay. I've referred to paragraph 43, 44, and 45 of the said judgment. From a perusal of the, taking into account that those three paragraphs have been cited to buttress the contention of the petitioner, the same is quoted hereunder. From a perusal of the above quoted paragraphs, it will be seen that the Supreme Court only held that the filing of the FIR in a particular state cannot be the situs for exercising the writ jurisdiction under Article 2 to 6 of the Constitution. It was further observed that the place of residence of the person moving a high court is also not the criterion to determine the contours of the cause of action in that particular writ petition. It was observed that while the writ petition, it was observed that a high court before which the writ petition is filed must ascertain whether any part of the cause of action has arisen within the territorial limits of the jurisdiction. Therefore, the above observations of the Supreme Court relates to maintainability of a writ petition challenging the FIR. And not the FIR cannot be maintained, which is sought to be contended, which that an FIR but not an FIR can be maintained under Article 2 to 6 of the Constitution, which is sought to be contended by the counsels for the petition. It is also well settled that the maintainability of the FIR would depend upon whether the said FIR, reading of the said FIR would disclose the commission of an offense. Article 2 to 6 of the Constitution. Your prayer says so. Then it's okay. No, I'm saying that. No, there I'm coming. There I'm coming. Wait.
This also will settle the maintainability of the affair to depend upon whether the reading of the said affair would
discloses a commission of an offense and not whether an FIR can be challenged under Article 2 to 6 of the Constitution. Therefore, the first contention so raised in the writ petition, in the opinion of this court, is totally misconceived. Now coming to the second contention, which have been raised, that the FIR does not disclose the commission of any prima facie case against the petitioner. This court had, in the foregoing paragraphs of the foregoing section of the instant judgment, had dealt with the judgment of the recent judgment of the Supreme Court in the case of Niharika Niharika Infrastructure Supra. Wherein at paragraph number 57, the Supreme Court had dealt with the principles now coming to the FIR, which have been enclosed as Annexure 3 to the writ petition. It is apparent that there are allegations to the effect that the petitioner, along with Sri Ritumoni Kolita, had cheated the respondent number 5 AIP 7. Whereby by dishonestly inducing the respondent number 5 to pay an amount of rupees 5,90,000 and on the basis of the said assurance, giving an assurance that upon payment of the said amount, the raw materials for broom making would be sent to the petition to the respondent number 5. On the basis of the said assurance, as could be seen from the allegations made in the complaint, The respondent number 5 had changed his situation. By paying the amount of this 5,90,000. And but did not receive the raw materials for the broom. These are all allegations which are required to be investigated upon. And as held by the Supreme Court in Niharika Infrastructure Limited Supra, it would not be proper in exercise of the powers under Article 2 to 6 of the Constitution to thwart such investigation. Consequently, this court finds no merit in the writ petition, for which the writ petition stands dismissed. Yes?
Decided what a court has got to obtain a reason. That was absent. But so far as they were validity of the affair, whether it is about prayer of judicial or in a judicial, to investigate this matter.
There, no.
I follow that I don't care.
I think that is a good ground for you to move the division bench. The court did not consider. Yes, go. What has happened? A charge sheet must have been in the meantime given. Because of the court, you must have said the court matter is pending.
This was on the next moment he was.
Right.
Because they were. Because my contention. I was.
Mr. Purkayastha, these contentions cannot be looked into under 226. You may have made the petition of an FIR of 2 pages of 86 pages. That is a different aspect. Yes. Next. Yeah. Anyway, a judge of this who normally does pension, he got now a judgment of quashing. Okay, next.
Item number 3, order no sale.
Yes, no steps. Can you say order?
Order no sale.
No steps. You are not interested? No, are you going to take steps or not? When? 6th of October. Where is it? So the receipt. Is it stay? What are you challenging? Directing the response to alter the location for setting new area, maintaining a distance of 10 for Iman situation at so and so Iman. What remains? Is there anything remains out here in the repetition? Then dispose of. And then we dispose it of unnecessary. What does it say? After hearing the learned council and considering the matter in discourse of the till the transport department of state government does not come up with new guidelines regarding installation and granting of license for new ATA, the respondent transport shall strictly follow all the specifications as provided by SIMS. That's it. Yes. The instant petition has been filed by the petitioner. challenging, seeking a direction upon the respondent authorities to alter the location for setting up new AETS by the respondent number 5, maintaining a distance of minimum 10 kilometers from the AETS of the petitioner, situated at village Madhavgaon, PO Jamuguri-Ghat, PIN 784180 in the district of Honitpur, Assam. The council appearing on behalf of the petitioner, as well as Ms. M.D. Bora appearing on behalf of the Transport Department, submits that similar petitions have already been decided by a coordinate bench of this court in WPC number 63 by a judgment and order dated 16/2/2022 in WPC number 6369/2021. Ms. M.D. Bora, the learned counsel appearing on behalf of the Transport Department, further submits that the said order dated 16/2/2022 passed in WPC number 6369/2021 have also been acted upon by the Transport Department. Taking into account the above, this court also disposes of the instant petition with a direction to the Transport Department to strictly follow all the specifications as provided by the Commissioner of Transport, Government of Assam in its letter dated number CT-AETS/6693, dated 29/10/2019. Till the Transport Department of the Government of Assam does not come up with new guidelines regarding installation and granting of license for AETS. Taking into account the above, the instant on the basis of the above, the instant writ petition therefore stands disposed. What are you challenging here?
The fraud of the online fraud,
Hmm?
it's an online fraud.
Hmm.
Where in the amount of around 70,000 by payment, small amounts, 2,400, 5,000 on same bringing infra, Amazon and such. And this amount is. So I made a complaint as well as an FI. Ultimately, the bank initially stated that there was a fraud. Subsequently, they stated there's no fraud. They have also going to be a bust.
You have come against the order passed by the banking ombudsman.
Of both banking ombudsman as well as the bank. Bank has stated, finally stated that it's a non-fraud feature challenge. And the order of the banking ombudsman. That is,
Wait,
Taking over the order is just 31.
these are all given on date. These are. But he is the ombudsman. Forwarded.
what is this INB account? What is the INB account? Page 31. So you have not taken steps.
That point of time. They're thinking, but subsequently, when the other two are looking at here, then we are taking the steps.
When? Mr. Y.S. Manandal, counsel appearing on behalf of the petitioner submits that the steps have been duly taken upon the respondent number 4 and 5 today. So, taking into account the above. List the matter after completion of steps upon the respondent number 4 and 5. Invited.
I don't think you internet, I.
Five for admission.
So. Yes, madam, what is your instructions?
Evidence already filed on the.
You have filed an affidavit?
We have filed an affidavit by superintendent of police.
No. Last time I have directed the Dhubri commissioner, the superintendent of police.
We have filed that.
You got it?
I got that.
What does he say?
He said, after transferring the gas color, another campus registered, number 3 on 2017. Subsequently, 28/8/2023, the FR has been published.
So what remains? What remains here?
And our alternative also there,
Have you given anything? Submitted the application? So that application you have to do. Without that, how can I issue a mandamus? I cannot. You have to apply. Can I issue a mandamus without you are approaching the authorities for it?
In my humble submission, he is agreed by inaction of the police.
Hmm.
17 is his,
No, prayer number 2.
yes, my lord. But nevertheless, but if that is his objection, my lord, then his remedy may lie elsewhere.
That is-
153 is there, my lord.
The instant with petition has been filed by the petitioner seeking a direction upon the respondents to recover the son of the petitioner from the hands of the culprits who had kidnapped him on 25/8/2016, and in connection with which the Borpeta PS case number 2226/2015 have been registered under section 365 of the Indian Penal Code. When a matter came up before this court on 25/9/2023, this court had directed the Superintendent of Police Dhubri to file an affidavit on or before 4th of October 2023, bringing on record the status of Borpeta PS case number 2226/2015, which have been transferred to Dhubri PS police station, as was intimated to this court on the basis of instructions dated 22/9/2023. It reveals from the records, it reveals that the additional superintendent of police, bracket crime Dhubri, had filed an affidavit pursuant to the directions passed by this court on 25/9/2023. In the said affidavit, it has been mentioned that upon receipt of the FIR, a case was registered as Borpeta PS case number 2226/2015 under 365 under section 365 of the Indian Penal Code. During investigation, the investigating officer found that the original place of occurrence of the incident falls under Dhubri police station. The investigating officer of the case submitted a petition before the Chief Judicial Magistrate Borpeta requesting to transfer of the case from Borpeta PS police station to Dhubri police station. The Chief Judicial Magistrate Borpeta passed an order to transfer the case to the Dhubri police station. On receipt of the case diary from the Borpeta case, a case was registered as Dhubri PS case number 681/2017 under section 13365 of the Indian Penal Code. During the investigation, the investigating officer examined the complainant and recorded his statement under section 161 of the CRPC and visited the place of occurrence and drew a rough sketch map, examined the available witness near the crime scene and recorded their statement under section 161 of the CRPC. The investigating officer also analyzed the mobile phone records for finding out the clue in the case. The various accused persons were arrested and forwarded to the judicial custody after interrogation. The investigating officer tried all possible steps to recover the victim, but no fruitful results were achieved. After completion of the investigation, the case had been submitted in FR as no clue, via FR number 489/2023, dated 28/8/2023. Taking into account the above, the remedy which now lies with the petitioner is to approach the concerned court wherein the said FR has been submitted and file appropriate application if so advised. This court further finds it relevant to take note of that in the writ petition there is a prayer made that the petitioner be paid the appropriate compensation as per the various schemes announced by the government. However, from the perusal of the materials on record, there appears that the petitioner had not approached the concerned authorities for the purpose of grant of compensation, seeking the compensation. Under such circumstances, no mandamus can be issued upon the respondent authorities for payment of any compensation as per the schemes announced by the government of Assam. Be that as it may, this court grants the liberty to the petitioner to approach the concerned authority by submitting an application, by submitting a representation along with all necessary documents to the Deputy Commissioner. The approach gives the liberty to the petitioner to approach the Deputy Commissioner, Dhubri. Dhubri?
District Commissioner Dhubri.
District Commissioner Dhubri, by submitting a representation there and also enclosing the various documents evidencing the fact that the petitioner is the next of the kin of the victim and as such entitled to the benefits of the said scheme. It is this court further observes and directs that in the eventuality such application is filed before the District Commissioner Dhubri, the said District Commissioner shall duly consider the same, and if found entitled to on the basis of the materials, shall forward the same to the Revenue and Disaster Management of the Government of Assam. The Revenue and Disaster Management thereupon, upon carrying out the necessary verifications, shall, if the petitioner is found entitled to, disburse the said amount to the petitioner, and release the said amount so that the amount can be disbursed to the petitioner. The said exercise be completed within a period of 6 months from the date a certified copy of the instant order along with the representation is submitted by the petitioner. That is for something else. Appeal.
Seven.
Your name, madam? Huh? M? Why do you want to withdraw? Why is that become infructuous? What have you asked for? Commanding us to invite and allow the petitioner to participate in the bidding of 4 tenders. Oh. The Learned Counsel appearing on behalf of the petitioner submits that the relief which have been sought for in the writ petition to the effect that a petitioner be permitted to participate in the bidding of the 4 tenders have become infructuous. In that view of the matter, the instant writ petition, in that view of the matter, the Learned Counsel therefore submits that the petitioner does not wish to further proceed with the instant writ petition. Accordingly, the writ petition therefore stands closed on withdrawal as it has become infructuous.
Eight.
Yes. You want to withdraw? You got the money? Huh? What? But relax. See, not me. They also have not understood what you have said. Tell me, what do you want? $2 lakhs, sufficient to rehabilitate the petitioner in terms with the notification stated so and so. Oh, this one, extremist. You want to withdraw or what? Yes, what do you have to say? Mr. Sharma?
Lordship, the person expired on 22/6/2004. Accordingly, at that time, the amount of compensation was 1 lakh.
Now it has become 3 lakhs.
Now he is claiming the enhancement.
Are all these persons? No, the problem arises, are these only for one?
Accordingly, it was divided among them, among these 4 petitioners, 25,000 each.
No. Finally come to paragraph 2. The petitioner begged to state that family members of the petitioners were killed by extremists prior to 22/6. The petitioners applied for ex gratia. The government had verified the application to the concerned and after proper way sanctioned an amount of ₹1 lakh as ex gratia only against each of the deceased demand earlier and so and so. All the petitioners, family members of the petitioner received ₹1 lakh against each deceased person killed by the extremists provided by the so and so. Killed and so and so. So against them, they are saying that they should be getting more. That the brother of the petitioner number 1, mother of the petitioner number 3, number 1, mother of the petitioner number 3, son of the petitioner number 4, were killed by the earlier amount was paid to the woman. But the incident has been filed by the petitioner number 1, 3, and 4 in place of the earlier incumbent along with the other similarly situated victims, so and so, being the surviving legal heir of the deceased. Mr. Counsel, you are there? Yes, tell me. I am also unable to understand. Page? Yes. No, these I know. You don't need to show me the law. I'm saying, how are you entitled to? Show me that. How are you entitled to? Yes. Show me that. Those figures only. I don't need the law. Huh? 841. These things I know. You don't need to teach me these. I'm asking you, how are you entitled to? Show your figures that they. How are you entitled to? How is we are having 4 petitioners? You are claiming against whom? That is what I am asking you. Where? So what is this chart? Yes, that I have read it. What is the paragraph after the chart? Tell me. After the paragraph chart, read it. If you understand.
Number 1 is 4 in case of earlier incumbent, 7 is other number being the providing legal.
So what do you understand by that? So there were some other people who have received 1 lakh. So why those people have not come? And why you have not mentioned who have received earlier? Why those people have not come? And the problem arises, do you know why? These should have been separately filed. All are different claims. How are you filing only one with petition? Tell me. That is the problem which arises. Each person has his own right to get. Your case is That earlier some other family member has taken 1 lakh, now pay me the 2 lakhs. Isn't it the case? Then where is your representation? Show me.
It's 45.
Yes. Who has filed? My goodness, how can this type of representation be given? Everybody signing it? Huh? What is this common representation business out there? Tell me, that is why you are not getting it. You should have filed it properly. You want one, you tell them that these are the facts on which I am entitled to. Why you are not doing it, all these things? Yes, you do properly, because otherwise the problem arises. Nobody understands head or tail about anything else. And the affidavit also makes it base more clumsy, the situation. What type of affidavit, who has filed this? Some deputy secretary or something. He makes it, oh, finance, you. Stating in very clearly that these are things, what is their claim? Paragraph 3 and 4 say that we shirk our responsibility, revenue and disaster will pay. The learned counsel appearing on behalf of the petitioner submits that the submits and admits that the petitioners have not represented before the authorities claiming the benefit of the notification, office memorandum dated 29/7/2013 in a proper manner by stating the necessary facts entitling the petitioners to the respective claims. The learned counsel therefore submits that he may be permitted to file representations before the concerned authorities and thereupon, if so aggrieved, may be permitted to approach this court. Taking into account the above, the instant petition stands closed on withdrawal. Liberty, however, is given to the petitioner to approach the concerned, the district commissioner. The district commissioner, which district? Now, this is home and political thing. This is not done. This is done under home and political. Have you made the home and political? No. Not revenue river. This is under home and political. This payment is being made under home and political department. No. Huh? No. These payments are being made by the home and political. Home and political is for some victims. Okay. Shall approach the district commissioner, Dorong, by filing appropriate representations. Shall not preclude the petitioner from approaching the district commissioner, Dorong, by filing appropriate representations. It is further clear that if the petitioner is agreed, liberty is further given to approach this court after a reasonable period. After the lapse of a reasonable period from the date of submission of the representation.
Item 9.
Yes. Oh, this one. This pertains to that Silchar. At the behest of Yahoo results, which resulted in the chairman passing certain orders. This court has reviewed it to material amendment, but nothing could be found as how the petitioner is effective with the installation of the lift, or the constructions were carried out by the respondent survey. Mr. Running the line, if you have submitted in file edition. You have file additional affidavit?
I think you have understood that there's some limiting in the family.
What? What is that?
They filed an affidavit to show that in the permission, there was a permission of the list.
There were no permissions.
There was.
Then?
And
And also show a photograph. Show where the lift is.
Where is the lift?
Please, 49 is the photograph, my lord.
Annexure D,
Annexure T, yes. See, lift. Left side is the lift, the feeder side, my lord. In between there is a train. The right side is a petition building. Petition building. There's a gap, my lord. So suppose I make statement, if it falls also, he's.
how will the lift fall down?
That's what, my lord. If it will fall in the box only. If
Hmm.
it falls also, in the box it will fall. It will not fall. That's what I didn't understand, my lord. How they. Please 44 for a minute, or it starts at page 40, page 44.
Mr. Boni, are you overwhelmed with what Mr. Emnath's high pitched voice? Did your voice has come down?
Not
Can you come
not
up?
at all.
Yeah,
What I say,
yeah.
if we go by drawing, at page 44,
Page 44,
page 44 of the writing.
54 days, another affidavit.
Yeah, only affidavit. Right.
54, yes.
Page 44.
Hmm.
Towards
Yeah.
the end, my lord, it is that lift
Where is the lift? Lift is there.
and the landing,
Hmm.
landing would bring the stair to the landing part. 45 also the lift goes up.
Hmm.
Without constructing the lift there, what they have taken it, what they have done is they have constructed the lift outside the building and constructed on the floor.
How do you say it to be outside?
Page 49 is outside,
Ah, it's not
page
outside.
44 is inside.
No, page 40, yeah, 49. Why do you say it to be outside?
This is the boundary wall. My one is taking a view, as if from the top of the building, that will be more second.
Hmm.
Towards the left hand side is the lift, there's a boundary wall, and then the right is the petition of building, that's what the is now. To the outside. I would have clarified, but for my difficulty,
Now, is the lift going to fall upon you?
my lord, there is a requirement under the rules, under the act in force, which says that a particular permission to be taken for construction of a lift. But this is their part, the authorities will understand what to do. Within this boundary, once a permission is given by authority, statutory authority, then the construction of a lift inside the building or whether the wall can take the load of it. When the permission is taken, the lift is shown to be inside, within the building.
So,
And when it is constructed, it's outside. The lift is not inside, the total lift is outside. But if the wall structure falls down, I'm on the other side. It will fall in my building.
why will the structure fall down?
Because unless authorized, certified, sanctioned, or approved, whatever was what you need to get by a statutory competent authority, the wall may not have, shall not have the capacity to keep the load of it. This is a thing, a structure which carries.
No, don't you think that this is a fairly a question of evidence?
Not at all.
Why not?
The point is whether I am affected, how I am affected, that I put to myself. If you construct a lift on the outer wall of a building without a permission as required by law, then in the event this falls down, it comes totally on my head. Building, risking my right to live.
How?
Therefore, I say, paragraph 14 is my petition period. That is the only case I think. Number one. So far, the other part, one shot the law is the authorities are in tune with me and said, we remove, they have not removed, they will take action, consequential action. This I say is clarified by this driver, this photograph.
So you just need a certificate that the lift is the lift is in order. I mean, sir, that the construction has been done properly.
If-
That's all.
If the statutory authority approves it, the joint and the lift are in two places. 44 and 49 are in two places. There is no two-way to it. On the same, it's the outside. Now, on the face of it, if constructed in the outer wall, when a wall is constructed as an outer wall, and the lift is constructed, not attached to it. With the inner side of the wall, when the lift is constructed, the permission is taken to see whether it will be the load of the building. It's a totally different construction area than the outer wall of the building. So what they have done for convenience, that they put it outside the building. The order of this intermunicipal board was that take it inside the building. They were so correct. They were the next place sanctioned and approved inside the building. They can take that building, but they put it outside. And on top of that, they filed an affidavit to justify that there was a permission. Within the inside the premises of the 4 walls. Now, I am appealing. It threatens my life. The wall collapses, he suffers a loss, it threatens my life. I come to this honorable for the reporting.
Tomorrow you may say that his building may collapse, the other side of the
Once
building
the
may also
building
collapse.
collapses, there is statutory permission to that granted for construction. The construction is not in violation of the building. Had it been so, the authority would take a call. Now, if they think they have constructed a literally outer wall, and I point out umpteen times that this would fall, but they're seeking two views.
What does the authority say?
The municipal board says, yes, take it inside. The applicant authority says, nothing, we will take fine, regulate. I mean, regularize. At this stage, before your lordship. when
No,
it comes
can the authority regularize it?
regularization or compounding, if I may put it that way, does not obligate the risk involved. It has to go inside or be removed. That is my case with it. The affidavit clarifies that we are on the wrong. I could have filed the affidavit because of some difficulties, some difficulties. I did not pay for time on that. I advised it. And when I went through it, it supports my case, sir. This is the difficulty. Now, if this be so, it will be taken as a thing for many things to come. An act is there, statute is there. You have
No. Can their lift be not regularized?
It can
Yeah.
provide it. It is constructed at the place marked, sanctioned, approved.
No. Can it not be regularized at a later stage?
And the wall cannot be reconstructed.
Why not?
When compounding of a deviation may be done, it does not affect life and limb. It is just in violation. Suppose a building walls have been missed, something from the shape, it goes beyond that.
No, your thing is that this may fall down.
It may fall down.
Okay, then you show us what is the basis. Barely because he is having a lift does not
No,
mean that it will fall down.
It's not my concern. He is constructing on a wall, but he is not supposed to take that load. If it falls down. it
Now,
falls
how do you
down.
say that it won't take that load?
Because there is no statement by the appropriate authority saying that even though, all right, he violated the terms of the construction, whatever plan was approved, they cannot approve a violation, first of all. I'm saying the implementation of whatever was there. They could approve a violation, number one. Secondly, they cannot insist on saying that this wall, whatever constructed, whatever strength it has, if you can put a lift, take this much of weight and the lift can carry people. That much will be beyond their jurisdiction.
That is also beyond this jurisdiction also to look into it.
Absolutely.
Yes.
The lordship
So
is
this
given-
court cannot do it. So go to the civil court.
Civil court would come when I'm challenging on a different premise.
No, you are challenging that this will fall down. That's that's only your
On the
question.
face of it, the construction of the lift has been made on the outer wall of the building, while documents suggest and show in no ambiguity below that it was.
No, your only worry is that this may fall down. That's all. Otherwise, you have no problem. You have a problem.
If it falls, and it's
No.
not
Do you have any other problem other than that it may follow?
so what lift is concerned. I cannot.
So under such circumstances, if it is, you say that it will fall off,
They do not say
Mr.
it will
Nath
not.
says that it won't.
But the
How
board
can
says,
this court decide?
the board says in my favor. The board says in my favor.
The appellate authority does not say in your favor.
It says. the
What
board
does the
says
appellate authority say?
appellate authority takes a call of regularizing the whatever effect is done. That may not be permissible in it. So far as the board would produce the record to show whatever permission was granted, that was the order of the last date meeting. That is also not forthcoming, and I think it is also not forthcoming. I say that in circumstances I could not find, that is a different issue. 27th of August, September, the last one. Paragraph 678.
Yes, records.
The permission and the statement. I find that there is no scope of any solution of the issue.
You are Hotel Ellora.
No, I'm the neighbor.
What is your hotel?
I don't know, that's the 6 story building, 6 story market.
You are
More-
Ellora.
More time. Even I purchased 1 pair of shoes my last year, my God, I went 6 years
Huh?
from his building.
No, you are the Hotel Ellora.
Yeah, I went to his building, my God, I went to 6 years. This is the original permission.
Anjali Nath is you. Yes, Mr. Dato, you were saying something?
So in fact, this permission was given by the development authority. Clear number for the board, the spend is there for the development. Now from there you also I see that the permission as such for the lift is not there. Now the sketch made on my director has shown that in a certain area, permission was given, but it was not constructed there. So now the lift was constructed there. Now the question is whether that is correct.
So you are the best one to say.
So what I suggest, you can set it there. If it can be certain, certain approach to authority. They will see.
No, that is what they have already done.
Otherwise,
No, isn't that the order which has been passed by the appellate authority? Saying that let them go to the SMB, SMB cell to consider realizing of necessary fees and fine and all. No, but the only thing is, the question is whether the lift would cause any damage or danger to the nearby location. That's the only thing.
yes, this is the only short area. So the question is, if it is not maintaining the setback was constructed, then there is something, because below the, so far the compounding is concerned, there is only little area where the chance of compounding is there.
the east, that will be property of 1 feet.
Hmm.
Now, those are to be maintained possibly will not fall in the purview of compounding the. Compounding is a very strict area, but if it is done accidentally or negligently. Now, out of accidental happening, 1 feet, area of 1 feet, under those circumstances to be done. But it is not that such type of field. It is, they have constructed within doing that, the setback will be affected. Obviously, if it is 2 feet away from the boundary, then setback is affected. So that is the area, only.
What is the setback? Setback, what, how much is the setback?
That better to take a special. Usually, different areas now, maybe different, but it depends. So that is better to take the thing.
Where are your records?
Now, my records, this permission is given by the development authority. So my record is, those records.
And Mr. Nath, what is your setback?
All stuff 3 to 4.
Hmm?
My
Hmm. Eight?
in between 3 to 4 feet now.
Where?
Actually, if I don't think it.
No, it will be there. The setback mention will be there very much in the permission.
Permission.
Permission there has to be. Violation detected in the setback.
That two neighbors at the same 5 London press building of the setback and page 14 and notice was given to a my lord for violation. At the correct date, then they have compounded page number 48. I have given it by law. Same thing in both the buildings. It's not only that in every building, little bit of division happens, my lord, and they compound it by law. And 48 notice was given to my London friend's client. That is the violation of setback, page 49, 48, my lord.
No, both of you fight out there. We direct that both the setbacks be broken. Isn't it? The Silchar Municipal Board shall take a call if there is any violation to the setbacks of both the petitioner and so they will take a call.
Yes, my lord. Yes, my lord. Yes, my lord. When it falls on him, it's a current. And the 6-story building, there's a setback. See, there's 48.
Yeah.
And here can reply to it saying,
With due respect, Mr. Nihal. Had it been a case of setbacks, whatever against me, all you have to be argument against, for the watch. This is not a case of setback at all. For the reason, in any building, let me be clear. Whenever a lift is constructed, it is within the premises of the building, so that it's a hollow structure. Even if it falls down, it does not fall.
We do one thing, make it more simpler. Mr. Datta, you do one thing. You instruct your people to submit a report as regards what is as regards the lift, as to whether it is situated in such an area which will be danger to the property. Then we'll take a call,
But the
because
fact
that is his only case.
But the fact that they are submitted on record, that there's no permission for them.
What?
You can submit the permission from the list. And the other hand, one has come shows that the permission was granted elsewhere, they were constructed there. That also is happening. To that extent.
No. I'm only going to see as to whether it is in a dangerous position. If it is not, why should I? You have any problem out there, do whatever you.
one more line.
Why?
Just see the setback of my 6 story.
That is not the case.
And everything else.
You have not, Why you have not challenged that order of compounding of them?
No, I have placed it before the principal. Principal gave a short notice to them. Then he has replied, then that from his reply,
But you have not, but you have not challenged his compounding.
my lord, two neighbors, my lord. Maybe my petitioner is a large hearted, my lord. He's feel of taking this small thing, my lord, 6 crore building. And
Does
again,
it- Therefore, it requires more area
That's
to take beyond the permission.
not like harm.
To fit in the-
Two women, my lord,
Huh?
staying in the poor. that's
Mr.
all.
Nath,
Fighting for.
does it take more area for that? Because of the large heartedness. Yes, yes, I give you 6 weeks time. This- Pursuant to the order passed by this court on 27/9/2023, Ms. M. Burman, the learned counsel, appearing on behalf of the respondent number 1 and 2 had produced the records pertaining to municipal appeal case number 3 of the 2016. It is also seen that the respondent number 4, respondent number 7, your respondent number 7.
Seven.
Have also filed an affidavit in opposition on 4th of October 2023. From a perusal of the said affidavit in opposition, it reveals that there was a permission for the lift, as would be apparent from Annexure B to the said affidavit in opposition. However, it is also an admitted fact that the said lift have not been constructed in the area as per the approved plan. Annexure D to the said affidavit in opposition gives a pictorial description, gives a is a photograph which shows where the lift presently is situated. This court has also duly heard Mr. S. Burnick, the learned counsel, appearing on behalf of the petitioner, who submits that the only anxiety of the petitioner is that the lift which have been constructed by the respondent number 7 outside the scope of the approved plan may be a danger to the property of the respondent number 7. So, taking into account the above, this court fixes this matter on 6th of December 2023. In the meantime, by 4th of December 2000, in the meantime, prior to on or before 4th of December 2023, the Silchar Municipal Board shall submit a report as regards the what? The whether the lift as it stands in the building of the respondent number 7 poses any threat to the building of the petitioner. What? It is one of the building of the petitioner, respond number 7 poses a threat to the petitioner. No, no. Whatever it is, it will be done properly. The records which have been produced by Ms. M. Borman is returned to be produced on the next day. Yes, affidavit filed. Affidavit in reply filed. Additional affidavit you filed. Then what remains?
My lord,
What do you want?
my lord, they have taken it just in the first round of when they have filed their affidavit, that is
To release the private land of the petitioner, occupied by the army authorities in a way already instead of in spite of that one. Where is Madam? Madam Gayan, where is she? Outlying bench. So you now take care of what she has done. What have you done? The period ended on some 2012 or 13. You remember that. Now tell me.
2007.
Then what are you doing all this while? Because on the last occasion, you told us that you are contemplating of having a lease or something to them to be done and all. Because otherwise we have no right. When are we getting it? And pay the compensation? 2 o'clock? 2 o'clock? Why? No, the persons, the property you have taken. This is not the manner in which you have done. The matter has been pending out here. What will the petitioner think that 5 years does it take for a small matter like this to be pending? It's a simple case. Then look here, there was an agreement to remain till 2012 or 7. Thereafter, they have been staying without entering into agreement. Nothing has been done, neither paying a single penny. You are army? Huh? Then, if the army is violating it in this manner, what remains? Can you do all these things? 2 o'clock. 2 o'clock. Okay, Mr. Counsel, we'll have it on some other day. When? Thursday? We'll dispose it of. Thursday at 2 o'clock. Let the matter be taken up, listed on Thursday at 2 p.m. for final disposal. 11. Oh, this one. Now you have, let me see why you want to withdraw. You want to withdraw? Who is coming? Respondent to set aside, recall the unaware of giving effect to the impugn notices dated so and so, and to direct the respondent not to take any step. Oh, this is eviction, madam. You have not evicted because of the interim orders. He wants to withdraw. I directed not to take further steps pursuant to the so-called notice dated 24/8/2018. My goodness. What is this so-called notice, sir? Letter bearing number so and so, it is seen that a plot of land measuring has been illegally encroached upon. Thereupon, if you have any document to show as to how the excess land was mutated in your name, then what is wrong? Letter of so-called notice has been illegally encroached, therefore you have to report as to how the excess land was mutated in your name, then the said documents should be submitted on demand in the year. And thereafter you have approached this court. Which one do you want? Withdraw, dismiss. And if you want to withdraw, where is your withdraw? You will submit your reply. The best thing is once you get a notice, the people should come over and file a writ petition. And this court will stay it for 5 years. And then the circle officer will change. A new circle officer will come in, who may not be of such person. Where is the senior? Yes, call him. Petitions. Who's next? Ah, yes, here he comes. Wait. Yes, whatever petitions you move, you have been asked to so call them to submit a document as to how you have put your 12 letters of land inside your land. Ooh, you say, why are you before this court? Huh? Withdraw. Okay. We vacate the interim order. Mr. P. Deka, the learned counsel for the petitioner, submits that he has been instructed to withdraw the instant writ petition. Taking into account the above, the instant writ petition stands closed on withdrawal. The interim order passed on 30/8/2018 stands vacated. The respondent authorities shall further take appropriate steps in pursuance to the show cause notice dated 24/8/2018, if so advised.
Patel.
Yes, what is this?
For particular IMY and there are some we have got in
No, now this is becoming fluxus.
2017.
No, IAY is no longer
Now even if
PMAY. Now the amount has also gone up. So the learned counsel appearing on behalf of the petitioner submits that as the matter pertain to the Indira Awas Yojana scheme, which has now been replaced by the Pradhan Mantri Awas Yojana scheme, where the parameters as well as the eligibility are different, he would not like to press the instant writ petition. Accordingly, the instant writ petition therefore stands closed. However, liberty is given to the petitioner to approach the concerned authorities for claiming benefits under the Pradhan Mantri Awas Yojana scheme, if so advised, if so permissible. Yes.
And the request was filed. This was with regard to non-payment of compensation
Non-payment of?
by the power grid.
Yes.
Subsequently, from the RTI, there has been information which we have gathered, which shows that in respect of the compensation which we were entitled to has been disposed in favor of third person. Now, this is some of the background, but I humbly submit before the court that the orders which are challenged for the order of the deputy commissioner and the additional deputy. But what it transpires that the provisions of law is probably the present subject matter is the Indian Telegraph. Now, rightly, wrongly, a restriction was in 2014, and accordingly, it was directed that the concerned authority to decide the issue. Because as per section 16(3) of the Telegraph Act, the appropriate authority is the district judge. But subsequently, a writ appeal was preferred. And in the writ appeal, the authority concerned was decided to get the deputy commissioner. And accordingly, parties approached the deputy. And deputy commissioner finding that only the compensation has been duly paid. But the order itself shows that only in respect of the stage of all the foundation. There are 3 stages in respect of all the foundation. But my humble and respectful submission before your lordship. In view of the RTA application, its record which has, it has transpired that they have paid compensation in respect of all three stages of work, but to different persons, not to me. To my humble and respectful submission, the remedy will be to the honorable district judge under section 16 subsection 3.
Then,
Since there is a round of litigation already, it's like there was an order.
so you mean to say the Retipilate court has conferred jurisdiction upon the deputy commissioner?
Yes, sir.
My goodness.
That was page 20.
Hmm.
So
Then-
that is so even if the jurisdiction was confirmed, it would be a nullity in view of.
That's a nullity. So the jurisdiction as per the act is with the district judge. So what do you want now?
Because I don't know what to submit because I have gone through the process of law. I was subsequently engaged.
Oh.
So I didn't have this writ petition.
Oof.
The law is very much clear, section.
There's another clarification. District judge.
Then,
That they have, instead of question this, they have come before.
where is that order?
This, sir.
Same petitioner.
Said this.
Then,
Okay. No, Pawan Kumar, his husband, this is Santosh Agarwal. Different petitioner, that is in respect of a different. That case is going on.
No, only this one.
No, no.
this is the husband.
Husband.
Husband is different.
I fairly submitted, I have gone through the record. Shown what has happened. Party approached the deputy commissioner, but the act does not provide.
Lahore. The instant writ petition was filed on 27/8/2018, seeking a direction, seeking a writ in the nature of certiorari for setting aside the orders dated 18/2/2016 and 22/5/2018 passed by the Office of the Deputy Commissioner, Kachar, semicolon, for a direction upon the respondent authorities to pay the petitioner the balance amount of compensation amounting to rupees 19,56,913. And further, a direction upon the Deputy Commissioner to inquire and submit a detailed report regarding the surface damage compensation payable to the petitioner in respect of the tower being LOC number 4/0, 4/0 bracket A, 5/0 and 6/0 of 400 kV DC PK Bari transmission line over the land of the petitioner. It reveals from the records that the petitioner initially, along with her husband, Sri Pawan Kumar Agarwal, had filed the writ petition before this court, being WPC number 4862/2014. Being aggrieved by the inadequacy of the compensation paid to them. In March 2012, The said petition was disposed of by an order dated 24/9/2014. Holding inter alia that under subsection 3 and subsection 4 of section 16 of the Indian Telegraph Act 1885, any party aggrieved with the assessed surface damage amount can approach the jurisdictional district judge for redressal. And as such, both the petitioners, including the petitioner herein, were relegated to the competent court. Being aggrieved, the petitioners thereupon, the petitioners in WPC number 4862/2014 filed a writ appeal, being writ appeal number 348/2014. In the same writ appeal, the counsel representing the writ appellants, who were the petitioners, in WPC number 4862/2014, which includes the petitioner in the instant proceedings, sought to withdraw the said writ appeal with a liberty to approach the Deputy Commissioner Kachar, the division bench of this court permitted the appellants therein to withdraw the appeal with liberty to approach the Deputy Commissioner Kachar, who, if and when such approach is made, will consider the case of the appellants in accordance with law and as expeditiously as possible. The record further reveals that the petitioner thereupon revealed that the petitioner herein, along with her husband, approached the Deputy Commissioner Kachar on the basis of the liberty so given by the division bench of this court in its order dated 24/11/2014, passed in writ appeal number 348/2014. Thereupon, orders were passed by the additional Deputy Commissioner Kachar on 18/2/2016 and 22/5/2018. It is relevant to take note of that both the orders were passed against, in the case of the husband of the petitioner. That is Sri Pawan Kumar Agarwal and not the petitioner. No, all these are claimants' name and address. Where it is there, it is given. Here, all these are Pawan Kumar Agarwal is not entitled to. Show me where Santosh Kumar Agarwal is not entitled to, has been mentioned. Page 28. 23 is what?
The representation that was.
I'm not concerned. Are these two orders passed against you?
Yes, sir, because
Are these two orders passed against you?
the representation was joined.
Understood. But are those two different, not different lands?
Yes, that's right.
So this is the fate you have.
This tower location is the
I can't help you. No, I can't. No, sorry.
Just one thing. The
No,
tower
no.
location 4, 4 and 5 and 6
It
is-
further reveals that a writ petition was filed by the said Pawan Kumar Agarwal. No, these are earlier writ petitions. Further reveals that the petitioner thereupon being aggrieved by the orders dated 18/2/2016 and 22/5/2018 has approached this court under Article 2 to 6 of the Constitution by filing the instant writ petition. And seeking the reliefs as above mentioned. It appears from the reports it appears from a perusal of subsection 2 and subsection 3 of section 16 of the Indian Telegraph Act 1885 that the district judge, that it is the district judge within whose jurisdiction the land have been, the rights over the land have been, do you have the Telegraph Act? Back up to 2 and 3 of the section 16 of the Indian Telegraph Act 1885.
As well as 4, my case would be under 4, but they paid to third party.
As per section 16, as per section 16 of the Indian Telegraph Act 1885. It is the court of the district judge within whose jurisdiction the property is situated. Is the authority to decide the inadequacy of the compensation as well as the apportionment of the compensation. This aspect of the matter was also mentioned In the order dated 24/9/2014, passed in WPC number 4862/2014. However, without noticing the said provisions and taking into account the submission made by the council appearing on behalf of the appellants in writ appeal number 348/2014. The division bench of this court had permitted the petitioner to approach the deputy commissioner. It being a well-settled principle of law that when the statute confers a jurisdiction upon an authority to decide, it is only that authority who can decide and not other, unless the statute permits. The deputy commissioner, which district? Cachar, therefore, could not have entertained the representation submitted on 28/11/2014 by the petitioners, or even pass the order which have been impugned in the instant proceedings. Taking into account that the deputy commissioner, Cachar, had no jurisdiction or authority as conferred by the Indian Telegraph Act 1885, the approach made by the petitioner by submitting the representation on 28/11/2014 and the subsequent orders so passed by the deputy commissioner impugned in the instant proceedings are nothing but non-est in law. So, by the additional deputy commissioner, impugned order passed by are non-est in law. Therefore, in that view of the matter, taking into account the order being passed, order dated 24/9/2014, passed in the writ petition WPC number 4862/2014, this court grants, again relegates the petitioner to the district judge, to the court of the district judge. No, petition, this court grants the liberty to the petitioner to approach the district judge seeking district judge against the order against the inadequacy of the compensation paid to them in the month of March 2014, if they continue to be aggrieved. The period with effect from 25/9/2014 till date shall be excluded while computing the period of limitation. It is, however, made clear that the deputy commissioner, that the district judge, while considering the inadequacy of the compensation, shall also take note of that the that it was on account of the fault of the petitioners. Now, take note of that the period from 25/9/2014 till date had Mr. Das, the question of if there is an enhancement, there will be a question of interest. And what happens to this period where they have delayed? This is not a small period. It's a 9-year period. Be taking into consideration from so and so till date, we take till the date of filing, if so till this court further directs that in the eventuality the petitioner approaches the district judge, Kachar, Silchar, no? Silchar. The district judge shall duly take note of that there was no fault on part of the Power Grid Corporation in the delay. After 25/9/2014, till the date of filing, till the date of approaching the district judge. Yes, what happened?
Lordship, this is the report, Lord.
You have encroached. In your presence, this demarcation proceedings was held.
The signature was taken in a, that question arose in my mind also, Lordship. It is taken in the attendance sheet, Lordship. It was sent to us in a abode mode, Lordship. You are unable to send it because of the food and error. Okay, no?
You do one thing. Put this thing in an affidavit. Mr. H. Sharma, the learned counsel appearing on behalf of the petitioner, on behalf of the respondent state authorities submits that pursuant to the order passed by this court on 2/8/2023, demarcation proceedings was carried out, wherein it was found that the petitioner had encroached upon, oh,
9 feet.
no, 9 feet, 2 feet somewhere and 9 feet is different. I'll give it to you.
During demarcation, it was found that the petitioner has encroached 9 feet national highway acquired land in the southern side and 20 feet in the northern side. And the
Had-
boundary
had-
wall of the petitioner is
Had
situated over.
encroached upon 9 feet
That is-
of land. N- 9 feet of NHAI acquired land in on the southern side. And 20 feet NHAI acquired land in the northern side. And the boundary wall of the petitioner was situated over the NHAI acquired land. Taking into account the above, this court finds it pertinent that the same aspect be brought on record by way of an affidavit to be filed by the SDO Civil Rangia. To list the matter again on when? And after the vacation, such small issues out there after the vacation. You have to just file it and state out there. Today is what? Today is 9th. File it by 16th. 16th October. File the, yeah. Because the matter, let the matter be listed on 18th of October. In the meantime, the affidavit be filed by 16th of October by the state authority.
16.
With advance copy to the petition. Yes,
Back affected.
give it. Yes,
Wanted warehouse owner. And since 1998, during the long course of business, kind of some materials got sedimented, which is required to be destroyed, which I did with due permission of the authority.
you destroyed it.
Despite with the permission of authority and under their supervision only. The destruction was carried out in the year 2016. In the year 2018, a demand was raised of the sum of
Destruction was done when?
2016.
When?
May.
Because 2016 is a very relevant period.
Why?
Because from 1/7/2016, the new act comes.
On 19th of June, 24th of
Destruction.
destruction.
Then
Thereafter, the amount was remitted, the levy was remitted, and it was also done on 31st of August 2016.
Hmm.
The demand was raised in the month of September 2018.
Hmm.
Saying that there has been some objection by the audit. And therefore we were to pay.
Hmm.
That is what I had challenged. Why is this clear cut fiber that since the inspection was carried out at the supervision of the Commissioner of Excise to his representative, number one. And number two, the materials had become unusable, not fit for human consumption. Therefore, only after chemical examination carried by the chemical examiner of Excise Department, the destruction was allowed. Now, the audit has said,
you were a bonded warehouse
Right.
at that point of time.
Right.
Now you are not.
still I'm continuing with the thing.
Understood, but are you still a bonded warehouse?
That now it has been renamed by the
Now you are a other one, na, the warehouse, wholesale.
wholesale warehouse.
So now wholesale.
Yes,
Yes. Earlier you were bonded warehouse.
earlier content.
So what is the impact, Mr. Council?
Uh,
In view of the new act coming in from 1/7/2016? If the destruction had happened prior to that, when they were not liable to pay the tax or excise duty.
Doctor, it involves the policy consideration.
And ultimately considers state revenue.
No, understood. Because at that point of time, there was no excise duty to be paid by them
They had to pay once it left the warehouse.
once it leaves.
Yes.
But if it has not left, it was destroyed with the permission of yours.
Yes, but it had to be destroyed because there are health and safety concerns.
Then, under such circumstances, how are you going to impose upon them? There are a few other matters also similar to that. Which are those matters? It has come today.
Yes, sir.
Which are those matters?
Budget is item 31 and 30. As well as 30.
But these are not destroyed.
Some-
These are dead stock. These are dead stock. His was destroyed. Or where yours? No, did the commissioner give it? We do one thing, we fix these matters for hearing immediately after vacation. Huh? Why?
I know the other is, contention is that everything has happened post first of September 2016. Whereas everything has already concluded way back. My inspection was carried out in June.
At that point of time, he was not liable to leave.
On earlier occasion also, this was done, actually my case, since it was totally different, on a different footing. It takes different consideration, my lord. That is my humble suggestion. Once again it is back, my lord, it creates confusion. Lordship, we have to first verify the factual aspects of whether it is only about stock reporting, and then there could be some stocks that
No, you must have verified it. Because there was as he is now continuing, so in view of that order of 29/6/2016, must have been a verification carried out.
has got
And he says that all these things were done prior to 29/6, the governor's order. So if it was done prior to 29/6, obviously those stocks would not remain in that, what do you call, in the custody.
Lordship will have to seek specific instruction to verify that fact.
No, that is his specific case, and when you have filed your affidavit, meaning thereby you know it. Isn't it?
Lordship, the affidavit only talks about the broad policy.
No, there is no broad or single or narrow policy. Here it's a simple case. At that point of time, being a bonded warehouse, they were not liable to pay. It is only the point of charge, or the point of charge is when it leaves the bonded warehouse.
That I'm aware.
And if we see the GST Act or the VAT Act, the point of levy is at the time when it left the bonded warehouse.
Prior to that.
So you still have that bonded warehouse need not pay as per you. But now they have become a wholesale warehouse in view of the fact that they don't have the money manufacturing along with it. So that is why now they have become. But at that point of time, and now also, if it is there in the bonded warehouse, there is no question of payment of excise duty.
Yes, but only clarify that factual aspect. They are contending that. all
That is the only factual aspect they are contending.
To verify whether everything is verified and on record, my lord, and they have already submitted their affidavit in opposition, my lord. May I take the opportunity to annex a 5?
What do you-
Everything is there, already there on record.
What do you have to say on that?
Lordship, just have a look. May have to file an additional affidavit because what is this may have to? We were under the impression that all of these cases involve similar facts.
So you didn't look into the facts and file the affidavit? Or just file the affidavit just for the sake of it?
We did lordship, but.
The perfect word would be the perfunctory manner in which an affidavit has been filed. Something like that. Just for the sake of it, I am filing an affidavit. Yes.
We have filed our affidavit.
Who are you?
The GO. The GO.
Yes. What is your stand?
There are 5 projects.
Yes. What do they say? What do you say?
The revision is the permission.
Remission of what?
Instead of 6 lakhs to 12,000. We have read the. It is because of the situation, the officers are responsible of officers have objected towards the revision of 6 lakhs by the Commissioner of Excise upon inspection.
No, understood. But Mr. Dawar, kindly tell me one very important aspect. When would they be liable to pay? Or are they at all liable? In respect to those. If they are not at all liable to pay in respect to them, where is the question of remission? The remission, if I'm not wrong, would only come into when they are liable to pay. Just for example, in a wholesale warehouse, the moment they bring it out, or as of now, the wholesale warehouse should keep those goods which have paid the state excise, as well as VAT, as of now. But at that point of time, they were not liable to pay, because they were bonded. So the point of charge would be at the time when it is brought outside. But if it was not brought outside at all, where is the question of remission or anything to the effect?
This is the audit report.
The audit report you may make many things. We still remember the audit report of 1,75,000 crores. Telecom scam, what happened? Then, this is the specific point. So if those things were destroyed prior to the coming into effect of the new act of 2000, which came, I think, on 1/9/2016 or something like that. So can they be at all be liable? It is something like they get the goods from the manufacturer. Now, just for example, while coming from the manufacturer to them, the entire stock gets destroyed. Should they be liable? No, at that point of time, because there was no state excise. The state excise would be the moment it leaves their bonded warehouse to the wholesaler or the retailer. Then if it gets destroyed, they will be liable.
I wanted just to clarify on that, but you want to file a detailed application.
Not the perfunctory one, not rely on that, the earlier one.
This was our preliminary instruction.
It's a preliminary affidavit.
We thought, need for a detailed.
Yes, your name?
I got.
Mr. Ibotaku, the learned counsel appearing on behalf of the Excise Department, submits that certain factual aspects needs to be verified, which shall be brought on record after due verification by filing an affidavit. List the matter on 23rd of November 2023. The affidavit be filed by 17th of November 2023. It is made clear that if the affidavit is not filed by the Excise Department, the instant petition shall be disposed of on the basis of the materials on the board. Interim order passed earlier shall continue till then.
Okay.
Yes, what are your matters?
That's right.
Which are your item numbers? These matters you are going to give any further affidavit? No, na?
There is an affidavit for item 31. But
You will file affidavit for others also?
yes,
इधर लिखो हाँ 18 साइटा बेलेग के लिए. The Learned Counsel, Mr. I. Botakur, appearing on behalf of the Excise Department, submits that in respect to WPC number, where you have filed the affidavit?
2901 of 2020.
2901 of 2021. The Excise Department has filed the affidavit. However, in respect to the other three petitions, the affidavit has not been filed, but will be filed by the Excise Department on or before the, as may be directed by this, as on such date as may be fixed by this court. List these matters again on 38th of November, 30 of November 2023. The affidavit be filed by 24th of November.
Lordship, there is an
I'm not
IA
fixing it together. Interim order is there. Interim orders passed earlier shall continue till the next stage.
But it is I item 22 is seeking improvement of finance, but then it is allowed. Moved by the
Who is asking?
finance.
Oh, that matter. Mr. Kane Chaudhary's matter.
No. You're right.
Oh, I have asked you. And I can do, huh? The instant application has been filed to array the Finance and Taxation Department. Finance or taxation? I don't think that you have made it to the Finance and Taxation Department. Is it? How?
Finance department.
No. You have to make the Finance and Taxation. Anyway, to include the Finance and Taxation Department of the Government of Assam as the respondent in the accompanying with petition, taking into account that the impugned demand which have been imposed upon the petitioner contains demand of not only of state excise but also VAT. Taking into account the above, this court is also of the opinion that the Finance and Taxation Department of the Government of Assam is a necessary party to the instant proceedings. Accordingly, the Commissioner and Secretary to the Government of Assam, Finance and Taxation Department of the Finance and Taxation Department, having his office at Dispur, Guwahati, is arrayed as the respondent number 4 to the accompanying writ petition. Mr. B. Chaudhary, B. Gogoi, anybody is there? You are there for whom? Who are you? Not nobody. Anybody has seen B. Chaudhary today? Or B. Gogoi? Anybody? B. Chaudhary. Mr. B. Chaudhary, the Learned Counsel, it will mean to be. Accordingly, respond number 4. The registry shall, on the basis of the instant order, shall make necessary corrections in the accompanying writ petition as well as update the same in the CIS. IA accordingly stands allowed. Main petition for in pursuance to the order passed in IA 2998/2023, whereby the Commissioner and Secretary to the Government of Assam Finance and Taxation Department has been arrayed as the respondent number 4. Mr. B. Chaudhary, representing the State Department, accepts notice on behalf of the State Department. Extra copy of the writ petition be served upon him during the course of the day. Mr. B. Chaudhary submits that he would like to file affidavit in the matter. Accordingly, let this matter be listed on 39 30/11/2023. In the meantime, both the Excise Department as well as the Finance and Taxation Department are directed to file their affidavit by 24th of November 2023. And he baki duta hetu order দিব দেই 30 31 হৈ গ'ল 31 32 this is 32 এটো হৈ গ'ল 33 and
31, 32. Next item, like another IA.
for
And for subdivision, because the deponent has accepted and the why subdivision, then I can find the.
33. 31 is okay, no problem. 31 goes to 38.
31 is, they are required to file that. Next item, they have already filed.
Where they have filed?
31. 31, they have filed their.
31 they have filed affidavit. 31 of tetu lekho, list the matter on 30th of November 2023, on which date an attempt shall be made to dispose of the petition. It is 31 hoy. 32 I have passed this order. 33 is what, sir? Is this 30? 33, where is the IA? There is no IA. IA isn't. No IA. You are on Debojyoti Bhuya.
Even from the, it was the last item.
This is 33.
32.
32 I have done it. I have done my Madhusila Roy.
That is the substitution method.
And where is that implement?
Even the early 30, item 30.
30 to you. 30 to you. Give me all the files. You are not clear on your files. Okay, no problem. Take it a 30, 31, 32, 33. List the matters of the vacations. You are not clear on which date the learned counsel appearing on behalf of the petitioner shall be clear on which matter to argue what. I am not, you don't know your files.
They have only in 31, they have filed.
No, you don't know. Why you are making the unnecessarily? You have said 32 is this.
Yes.
No, okay, you wait. We'll pass orders when it is necessary. Ekita order no. Ya khali hetu matter hetu. The first hetu lolu no. Mr. S.K. Singh. 15.
16.
Okay. Ekita matter ekita pasta bojat no.
17.
Yes, what is this? Compensation for what? Yes, the electrical accident report, does it say that it is their mistake?
Oh my God, it says that it's a extra road.
Then
Person was playing with the bamboo.
you are playing with the bamboo. What is there to play with the bamboo? Better file civil suit. This court can't give you anything because there is no fault. Causes of the death, you were playing with the bamboo. Huh? Yes, page 4. D. Causes of the accident. What has happened? it appears that while the victim was playing with one of the bamboos, he tried to swing the bamboo. Few of those bamboos were inclined to the other side of the road, and the upper end of some of those bamboos were hovering above the 11 kV overhead line. Because of the activity of the victim, the upper end of the bamboo got in touch with the bare line conductor of the kV overhead due to undulating motion of the bamboo. Then the upper end of the bamboo caught fire from the conductor of the so and the victim got electric shock through the ear. Electric. So this is your fault. What is there to play around with this 11 kV line?
He was not 14 years old boy, my lord.
So
And therefore, my lord, is there now, now, they have also.
what were you playing with the 11 kV well? The compensation should be paid to by you for filing a writ petition. It's your fault. Your fault. You are the father. Who are you? Father or mother? So why you couldn't take control of your son? Then
My lord, they are conservative, my lord.
Hmm?
Oh, he, my lord.
clause is what? All electric lines and apparatus shall be sufficient rating for power insulation and estimated fault current and of sufficient mechanical for demand which may be required to perform under environmental condition of insulation shall be constructed, installed. So and so this is
Therefore, is not a.
in such a manner as to ensure safety of human beings. No rod pipes or so and so shall be brought within the flash over distance of air. But where is the contravention?
Is there if one of two, one of clear the bamboo, my lord, from the.
It is not been stated that they have done it. It is partly yours also contravention on the part. No rod pipes or other similar that shall be brought within the flash over distance of bare live conductors or lines. Then if you play with that, it is your fault. You should have taught your son not to do it. Okay. You earn the 4 lakhs. Not possible. What to do? Civil suit. It is the only way. Huh? So you go there and put a hand on the live wire out there, or put your hand inside the transformer, and then you come up and say that, oh, I died.
Electrical back on a passes of bamboo.
If it was the electric line which fell on the bamboo, it would have been different. But here is the case, you, with the bamboo which your son was using, he tinkered with the electric line. This is the problem. Until, what to do? Withdraw? Approach civil court? But not this. You have an appellate authority.
We have a, but yes, it's a report of the report.
Challenge the report. Before whom?
Because,
Civil suit. Better know. You have to, these causes leading to the accident has to be set aside by competent court. What to do? Dismiss? No. The incident application has been filed by the father. Of one father of a 14-year-old boy late Rasidul al-Islam claiming compensation of an amount of rupees 10 lakhs from the respondent APDCL. From a perusal of the writ petition, it reveals that on 15/4/2018 at about 5:10 p.m., the son of the petitioner got electrocuted at Moripam near 1470 number primary school under Bagbor police station due to electric short circuit through bamboo, and the son of the petitioner died on spot. Under such circumstances, an FIR was lodged before the Mandia police outpost, and the same was later on registered as Mandia PS UD case number 02/2018. The petitioner thereupon submitted a representation on 29/6/2018 before the Assistant General Manager, ASCB Borpeta, seeking appropriate compensation for the death of the son. However, as the said amount was not paid, the petitioner has approached this court under Article 2 to 6 of the Constitution, claiming an amount of rupees 10 lakhs as compensation. It reveals from the records that on 1/2/2019, this court had issued notice. Subsequent thereto, on 15/7/2019, this court had directed that a report of the respondent number 4 be placed. The record further reveals that the respondent number 4 had filed an affidavit to the said filed an affidavit on 5/4/2021. To the said affidavit, the inquiry report of the electrical accident dated 26/3/2019 was enclosed. From a perusal of the said inquiry report, it reveals that the cause of the accident was that the son of the petitioner was playing with one of the bamboos and he tried to swing the bamboo. Few of those bamboos were inclined to the other side of the road, and the upper end of some of those bamboos were hovering above the 11 kV overhead line. It was on account of such activities of the son of the petitioner, the upper end of the bamboo got in touch with the bare live conductor of the 11 kV overhead line due to undulating motion of the bamboo. The upper end of the bamboo thereafter caught fire from the conductor of the line, 11 kV line, and the son of the petitioner got electric shock through the bamboo. Which led to the accident and the eventual death of the son of the petitioner. From a perusal of the said electrical accident report, it reveals that the accident happened on account of the son of the petitioner. Mr. R. Ali, the learned counsel appearing on the petitioner, however, disputes the findings in the said electrical accident report, stating inter alia that the live wire, submitting inter alia, that the live wire that the son of the petitioner was electrocuted on account of electrical short circuits through the bamboo and not due to fault of the son of the petitioner. Taking into account the above electrical accident report, as well as the contention of the learned counsel for the petitioner, that it was actually the fault of the APDCL authorities. This court under Article 226 of the Constitution is not in a position to adjudicate such disputed questions of facts. More so, till the electrical accident report is not set aside. The accident report is not set aside in accordance with law. The said electrical accident report shall hold the field. Under such circumstances, this court is not inclined to exercise its jurisdiction under Article 226 of the Constitution. Be that as it may, the petitioner herein would be at liberty to challenge the electrical accidents report, as well as also approach the appropriate competent court seeking compensation as mandated under law. What are these matters? Huh? Then, did I pass any orders? Oh, I passed. This is the matter on when so on which state that they shall place the records in original pertaining to acquisition of Iman in LA case. Okay, you have the records. Okay, Mr. J. Hendig appearing on behalf of the Revenue Department, on behalf of the respondent, on behalf of the Deputy Commissioner, District Commissioner, which one? District Deputy Commissioner Collector Karimganj has submitted that he has received the records pursuant to the order dated 25/9/2023. He, however, submits that said records have not been, and that he is yet to peruse the said contents of the said reports. Taking into account the above, list the matter again on 13th of October 2023, on which date Mr. J. Hendig shall produce the records again. Why 12? Why 12? These matters, they don't require acquisition, these are small matters.
All right.
21.
Yes. Mr. Mohanta, there is not two, there are three departments. One is that day I could get hold of. This WPC department has been not bifurcated, trifurcated into three. One is the social justice, one is tribal affairs, one is Bodoland.
Social justice was otherwise, social justice was with the social welfare department. Now,
Now it has been changed.
No, this has been WPT and BC department has now become three departments. One is social justice, the other is tribal affairs. Women in China. No. One is tribal affairs and the other is Boroland. Yes. There is another one. That is the third one. That day Mr. Dhar was telling me, Dhar. That is what another department. Okay, now what is it?
Lordship of the earlier occasion, the report has been sent to which department? In fact, I have placed the letter of the deputy commissioner. I have placed the letter of the deputy commissioner.
What is this matter about? I forgot a bit.
Conducted in respect of this letter from the members.
So cause as to why the report should not be sent to the commissioner and secretary to the government of Assam WPT department as per the letter dated demand and direction not be issued to the deputy governor to send the reports. To send the report only.
Yes.
Now what has happened?
In our affidavit, we have said that we have already, okay, report has been sent in Amman. Lordship wanted to know to which department. In the month of April, it was sent, because then it was sent to them.
Yes. Then, so it has been done. Then what remains? Nothing.
No, that's it. That's the important topic. According to. There would have been power play on the things and.
But that is not a prayer. Your prayer is limited. Should not be sent to the commissioner and deputy as per the letter dated so and so and direction be issued particular to send the report. That's all.
The report was not coming.
So should I say something more than that?
That's why they now the report has come, they have forwarded it. They are everybody to look into it.
Okay. The instant repetition has been filed by the petitioner. Petitioner, how many?
What?
Petitioners. It's by petitioner seeking a direction that the report. What is this report? Which report?
Report as it is the status of
The inquiry report.
temporary.
That was directed.
Inquiry report of 1998.
Regarding. Yeah, letter is 30 to 10/20. That's there. As per that, there is a direction to employ from the report.
No, this report, Annexure A to the affidavit,
That was the report.
that is the report. But that report, this report only came in 2023,
After the.
filing of the writ petition.
That's why. There was two.
The instant writ petition has been filed by the petitioner seeking a direction that the report which is required to be submitted be sent to the commissioner and secretary to the government of Assam WPT and BC department as per the letter dated 30/10/2018 and direction be issued to the respondents, more particularly the deputy commissioner Dorong, to send the report. It reveals from the records and more particularly the affidavit in opposition filed by the respondent number 3 and 4 that the additional deputy commissioner Mongoldoy had submitted a report on 29th of March 2023. On the legacy issue of Muslim fishermen living at village Bagpori of Dorong district. This quote further on 27/9/2023 sought instruction from Mr. Deenat, the learned senior government advocate, as to which department the said report is required to be sent, taking into account that the WPT and the BC department had been abolished. Today, when the matter was taken up, Mr. D. Nath submitted that prior to the abolition of the, prior to the reorganization of the WPT and BC department, the said report dated 29th of March 2023 had already been submitted to the Secretary to the Government of Assam, WPT and BC department. He further submits that pursuant to the said report, who is taking care of now? Who is taking care of? Now that department is not there.
Relates to status of OBC. Ultimately, because after segregation, the earlier WPT and BC have now we have backward classes department. That is possibly useful.
What is the department's name? That is what I asked for.
There is a department of welfare of backward classes.
Or backward class. That is,
Backward
are you sure? He further submits that pursuant to the submission of the said report to the Secretary of the WPT and BC department, after reorganization, the DES department is taking appropriate steps on the said report. Is said department is considering the said report. Taking into account the above, that the report had been duly submitted on 5/4/2023 to the Commissioner, to the Secretary, to the Government of Assam, WPT and BC department. The relief which has been sought for in the writ petition have already been redressed to. Further to that, as submitted by Mr. D. Nath, the new department, that is so and so, is considering the said report. This court finds no reason to pass any further consequential directions in the instant writ petition. It is, however, observed that if the petitioner is aggrieved pursuant on non-consideration, the petitioner would be at liberty to approach this court. The instructions so placed by Mr. D. Nath is kept on record and marked with the letter X. Ready. Yes. Contractual. Which department? Oh, PWD doesn't appear before the court. Yes, PWD is there. Yes, tell me. You want 7,04,000. Verify and pay. Taslim Ali. Taslim Ali, what is that? Tamsir Ali. No, Tamsir Ali. Because otherwise you should go, no? Either temporarily, PWD contractual bills payment.
What has been considered in the year 2014,
What?
the year 2014 has completed the work.
Mr. Council, 2014, if it was completed, your period of limitation for filing a suit is 2017. You have approached this court in 2020.
Otherwise, other representations are there.
Representation does not enlarge limitation.
And in the constitution,
Enough. Too much. The verification, you do it 1 month. But payment as per council.
I guess.
Yes. Mrs. Bora appearing submit the inquiry has been conducted in prepared litigation to be taking into account. Yes, you have filed affidavit.
Firewise comments, the activity is also ready.
You filed the affidavit.
All there is one here.
Huh?
Whatever this, 10 and 11 number, Bible is correct. They are ready to come back from it. And they have distributed our money, so they, when they break an out, you know, it's the, come back from the mini bank. That's a bag of, one, three, it's not we want. Now, the private buy the business of the, there is no chance.
Police has not registered an FIR.
Yes.
Why you are not going under 156(3)? Huh? Why you are not going before that police? Further direct the district police administration as well as to register all FIRs under the appropriate provision and initiative. Have you given the FIR? It has not been registered. So why haven't you moved under 156(3)? That's the law. Then so we can't help you. When are you filing it? This court directed you to file by 4th.
But we have written to the officer, but Lordship grants me a week's time.
Okay. Ms. S. Sharma, the learned counsel appearing on behalf of the state respondent submits that the affidavit is ready. The affidavit to be filed as per the directions passed by this court on 29/2023 is ready and will be filed by 13th of October 2023 without fail. List the matter on 18th of October. I'll make it filed by 16th October. List the matter on 18th.
24 and 25.
Yes, what is this matter? Will you file at last? What is the matter about? BDO. BDO says how much? Says that for the MI payment of refunds already released. Oh, 14 lakhs 9,000 you have released.
No matter, that is which part?
So then
I am for material part.
material not paid.
Not single thing.
And that is the affidavit.
Yeah, I can clarify,
Huh?
clarify.
Yeah, so that for the record, the payment could not be made by the authority as because the scheme was inquired by the inquiry and herein submitted to commence as work as per the provision in estimate is found to be incomplete, no further payment is required.
But I am supply of that. I'm not contractor is not clear, or
Huh?
if you have a contractor, clear, I am a supply, I supply to material.
Then where is the question of wage?
Wait for them. Get this, there is two parts. One main part, one material part. It is under PCF. I will kind of.
Show me, no, show me your work order.
Pilot page.
Which requisition? 854? 854? Yes, which one?
Page 23, my lord.
23. I request you to supply the following materials as below mentioned. These. Hailakandi Development Block.
Then my lord, your lord, find my lord, page 25,
Page?
25, my lord. I
Uh,
have supplied the material, my lord. Page 25, material was received by next week, it is actually last week, my lord. Page 25. My lord, certified that the material in good and good condition.
How much amount you are asking?
Yes, my lord, 14,32,858. Now, my lord, your lordship will find in case 28 next supply order.
No, they have admitted somewhere. Where?
Yes, my lord, in page 25, my lord.
No, that is they have only signed, passed.
Yes.
But where is the admission?
Now, my lord, your lordship will find page, annexure page 61, my lord.
Hmm?
Page 61, my lord.
51.
61, my lord.
Hmm.
FPO transaction, my lord. FPO is made after verification.
Who has done this?
Done by the video, my lord.
Where? You are referring to page 61.
It's 61, my lord. 51.
51. This one, yes.
FPO transaction, my lord.
Hmm.
FPO means fast fund transfer, my lord.
Hmm.
It is done after verification of everything, my lord.
Hmm.
Your lordship will find serial number 456, my lord.
Hmm.
Some amount total 5 lakh 7,000 something. Next week, my lord, that is your lordship will find next week 4 lakh 3,100 there. Then your lordship will find next week 5 lakh 21,953, my lord. Now question is that, my I am a supplier. I have supplied it. Whether what was executed or not, I cannot be held responsible for that. Because my responsibility is limited, my to supply the material.
Chalo. And what about the others? Other same time. They also have to do it. Huh?
The other one, madam, the amount. That is also my lord.
What is that? As per inquiry made by them, an amount of rupees stands payable against the scheme construction of so and so. Out of the payment payable, appeal of so and so was released for payment to be made, but the payment was rejected and not credited of the guy. Again, on demand, while releasing the date was noticed that the name of the vendor and the amount is not showing in read mode. What is this read mode? Yeah? That in response to the contents of area, they state that as per the summary report of the technical, the materials supplied by the supply reflected the measurement of work. And accordingly, the payable amount stands as. So you are admitting. What is it? No, the deponent state that as per the summary report of the technical persons, the materials supplied by the supplier reflected the measurement of the work. And accordingly, the payable amount stands at rupees 1,40,000.
Petition, the amount of 11 lakh 9,000. My lord. There is also same thing.
Yeah.
I have supplied the material. Now they have measured the work, my lord. Whether work was executed or not, how much work was executed, my lord. I am not responsible for that, my lord. Your lordship, in this case also, my lord. Page 44, my lord. What happened, my lord? It is not supplied the material, my lord. Actually, work was to be executed by the employee of this department itself, my lord. There is no permission for introduction of contractor, my lord, and that's the year. My lord, what was not executed due to therefore the part of the employee, my lord. Now they are saying that no, work is not there. We will not pay the amount. I am supplier, my lord. Whether there is any dispute regarding my supply, that is to be employer, my lord. My lord, can you see, my lord?
No, understood. But what order can this court pass?
My lord, after after verification of supply order. It was, my lord, it was uploaded to the website, my lord.
No, that verification is not proved. This court cannot sit as a civil court. Therefore, what order can this court pass?
My lord, that is not dispute, that is supply of medical. Now, the dispute is
No,
that-
how can we know? Have they admitted that you have supplied?
yes, my lord, that is execution, my lord. Because it is itself.
Are they? That these are questions of facts. We are to assume that everything what you say is gospel. Now, whether they have at any stage admitted that yes, this is the amount, because this is the question, this document is a subject matter of proof. In a civil court, if you have gone, how will you prove this document?
Now, my lord, case, yeah, it is the first, my lord.
Hmm.
Case 57, my lord. Para 4, my lord. In response to the contract of para 5 of the, para 3, my lord, in response to the contract of para 1 to 11 of the equivalent has no command of us. And in para 11, what I have stated, my lord.
You want to say that this court should pass orders on the basis of the doctrine of non-traverse?
Now, they have not disputed, my lord, my supply. There is no. Go ahead
So-
and they are able to give you a position that whether I have some type of. Now, they are saying that.
Mr. Devnath, why don't you file an affidavit? As regards, because he says, the question of him, he is merely a supplier. And if he is a supplier, he's not bothered whether the work has been done or not, because the work has to be done by the departmental officials. So he is supplied, which the authorities have duly admitted. And as such, he is entitled to, for the materials he has supplied. You file your affidavit to that effect, whether he has supplied or not. It's a different petition of the liquidative. It reveals that pursuant to orders being passed by this court, in both the petitions, affidavits have been filed. In the said affidavits, it has been mentioned that the works in question, in respect to which, in both the affidavits, at paragraph number 5, it has been held that the petitioner is not entitled to the amount as claimed, on the ground that the work had not been completed. It is the specific submission of the learned counsel for the petitioner that the petitioner had only supplied the goods in question. The question of implementation of the work is to be done by the department, as that is the mandate as per the scheme. And as such, whether the work was implemented by the department or not is not the subject matter before this court. The learned counsel submits that in the instant case, the documents would clearly show that the petitioner have duly supplied the goods, and as such is entitled to the amount so claimed. Taking into account the above, and more particularly, as the affidavits so filed by the respondent authorities do not disclose that do not disclose anything as to whether the petitioner had supplied or not. This court, in the interest of justice, grants the respondent PNRD department to file an additional affidavit by 17th of November 2023. List the matter again on 24th of November. File additional affidavits in both the petitions. Why? Why?
There are. I think it's not like we. Balance sheet. Means so, the petition made the representation and then amount. However, subsequently, the petition has been rejected from the chartered accountant, and he made the claim that 75 crore some amount needs to be refunded by the government favor. But now, however, he's not interested in it.
The learned counsel appearing on behalf of the petitioner submits that the instant writ petition was filed seeking a direction upon the respondent bank to reassess the loan account of the petitioners and to refund the excess amount received by the respondents. The said basis for filing the instant writ petition was on account of a scrutiny being made by the chartered accountant on 17/2/2018, which showed that the petitioner had paid in excess rupees 7,95,831. It is the submission of the learned counsel for the petition that on further reconciliation of the accounts, the petitioner accepts that the amounts which have been refunded to the petitioner, or that is rupees 2,21,039 by the respondent authorities, the respondent bank, is the correct calculation so that for which the petitioner would not like to press the instant writ petition. In that view of the matter, the instant writ petition stands closed on withdrawal. Give your names. Yes. Yes. Then
And it's about holding the field. In between us from the movement of offer, that was defined at page 26. Order was by the student officer.
yes.
Now, page 27, second paragraph. The applicant has been accepted that the grant is included in the sector patta, even in the name of representing player and active. No objection has been made against the sector patta by the respondent or anybody else within the last 7 years. The sector patta referred to the above remains very lawful and binding. The planet ASO does not have any lawful record land under the same person until and unless the sector patta is established themselves or corrected in the
Then,
Then in not case 29. To the settlement officer on the strength of the order. Then case not 30 to the deputy commissioner on the strength of the order of the settlement officer. And finally, not on
what do you want your name to be included?
our respondents name to be relatives from the sick party. As per the order of the settlement officer.
So after the order passed by the settlement officer, the said order should be given effect. That is what you want. And respondent authorities are not doing it. That is your civil. Yes, you are appealing for? Yes. What is your case?
That I need to file affidavit, you know, this is my particular.
For what?
To clarify certain allegations that they have made. And here in this case, you also see the prayer person. Prayer question of the.
Their person is too many. I'm not on that. He only wants his name to be included out there on the basis of the settlement orders order.
On the strength of the order passed on 2/11/2010. So after the 11 years he came.
Hmm.
So we have serious doubt about this order. Also. That we are in possession, we are not in possession. No, we are in possession. I am in possession. I am in possession. So this order,
No, but Mr. Counsel, this order is subject to an appeal. You can file an appeal against this order. Why haven't you filed an appeal?
only we get to know by when they file this writ petition.
When did you file to come to know? You are,
21, but we got the notice in the 23. And this is our first appearance.
you are for respond number 10 to 16.
Yes. We need some time to file affidavit.
The learned counsel appearing on behalf of the respond number 10 to 16 submits that he would like to, he will seeks in, that the said respondents would like to file an affidavit in respect to the allegations contained in the petition. This court had also inquired with Ms. S. Sharma, the learned counsel appearing on behalf of the petitioner, on behalf of the respondent state as to why the order dated 2/11/2010 passed in Miss Case number 3/2/2009 by the settlement officer, Dhubri and Pokrajhar districts, Dhubri, have not yet been implemented in spite of in spite of various representations being submitted by the petitioner. Ms. S. Sharma submits that she will also obtain the necessary instructions according. List the matter again on 29th of November 2023. The affidavit be filed by the private respondents by 24th of November 2023.
Okay.
In this case, everyone is one case file affidavit. Like.
Mr. P.J. Sekar appearing on behalf of the petitioner submits that the respondent number 2 and 3 has filed an affidavit in opposition. The said affidavit, however, he further submits that he would like to file a reply to the said affidavit in opposition. It also transpires from the records that the said affidavit filed by respondent number 2 and 3 is not on record. Let the registry list the matter again on 11th of December 2023. Their replies be filed by 6th of December 2023. The registry shall also bring on record the affidavit filed by respondent number 2 and 3.
to 38.
Hmm. আর এটা আছে না? 35, 36, 37, 38. হ্যাঁ? এটা মেয়ে। মেয়েটা কি দিও? You are appearing for 35. Who is appearing for 36, 37?
Some other computer.
What are these matters?
Period. There are soft period, my lord, particular area that everything is considered for prediction that has been-
35 is yours.
Yes,
3167, 65. What is your case?
during the curfew period, my lord, some prediction that is done by the government, my lord.
During the,
During the curfew period, my lord.
what is this curfew period?
Thousand. Thank you, my lord.
Uh,
Now, approved earlier before the honorable board is WPC number 7710, 7701 and 2017. There is a-
7701.
Same list, my lord.
These.
Here, 5 my lord.
Uh,
There is a enough order.
uh,
Otherwise, it's honorable board. There also, my lord, on 19/6/2021, when there was COVID was there, my lord. The government has, limited some of their costs, like nearby costs. So we have approached the honorable board by filing this litigation. And they also this board has passed the status quo. That's why in fact, there our public also evicted. And now this one part has been already been constructed by the government.
Huh?
One children's park has been already constructed.
Yours? Children Park. You have been evicted. All of you.
Saying by the government, land. This is the
Huh?
government, land. That we are saying, policy the government, land. We are affiliated with the government.
No, you are not possessing your own land.
I am saying that I am, in my land, but just for the government, resettlement, for some under the government land, therefore government has evicted, thereafter the children park has been constructed.
So in all of your lands, it is now a children park.
Yes, absolutely. Yes. Absolutely. Yes. Absolutely.
Whatever may be. But it is a children's park now. So all the repetitions have become infractions. All four, na? You are appearing for 7701, 7702, 7648. The- You are appearing. The learned counsel is appearing on behalf of the petitioners in the four writ petitions submits that these writ petitions were filed challenging steps, proposed steps taken to evict the petitions. It has further been submitted that in the meantime, the petitioners have all been evicted, and on the said land, a children park has been established. Have been established. It has been therefore the submission of the learned counsels for the parties petitioner that all the four petitions have become infructuous. Taking into account the above, all the four petitions stands closed as it has been infructuous. Interim orders which have been passed, all stands vacated.
Thirty-nine.
And Modi is already 100% come. Modi is also 100% come.
You are appealing for?
Number 4.
You file affidavit.
Say that's right. Well, more than 10%. That is very.
Hmm?
Well, more than 10%.
Oh, that one, below 10%. The instant petition was filed challenging the letter of acceptance dated 15/5/2021 issued to the respondent number 4. And also challenging the impugned email dated 16/6/2021, whereby the petitioner's bid was cancelled. It has been submitted by Mr. B. Goswami, the learned additional advocate general, that the work in question have already been completed pursuant to the award. The learned additional advocate general further submitted that nothing further remains to be adjudicated in the instant petition. Taking into account the above, the instant petition therefore stands closed as it has become infructuous.
40.
Hmm. Yes, file affidavit.
She filed her affidavit. I have the office copy, but as for my clerk, my lord, just called me and apologized that he forgot to file it for the registry, but he gave me the office copy as for the case papers. It's not there. My lord, he gave us a week's time. I have the copy which is the.
Okay. What is this matter about? As to whether the inquiry as ordered by the order dated so and so have been completed and whether any report have been submitted in that regard. Mr. P. Hendig, appearing on behalf of the PNRD department, submits that the affidavit so directed to be filed by the order dated 22/9/2023 have already been filed.
I think filed, my lord, as.
Have already been filed. Full stop. Mr. F.U. Borguya, appearing on behalf of the petitioner, submits that no copy, however, has been received. Mr. P. Hendig undertakes to serve a copy of the said affidavit during the course of the day. List the matter again on 18th of October 2023, on which date the registry shall bring on record the affidavit filed by the PNRD department.
You are.
Yes. Release the compensation for the share of land as per the present according with the rate of interest. What is this? What are you asking? Compensation for what? Till now? Where? Under what provision? You are the owner of the land. Huh? Where is it? Okay, then you have not been paid the compensation. Till date.
But as per my last instruction, that irrigation department is going to make that payment manner that estimated already in time of the.
Okay. When was the land taken? Then you return the land. Yes, irrigation. Hmm. For what? Return the land if you are not in a position to pay. You can't keep this land from 2011. No. The land, what you have done to the land? Huh? Oh, so give them. You want the land? You want the land? You want to give it back? No. You cannot. You cannot have this land without paying a payment of compensation. Person's rights you have taken over. Then leave it at tomorrow at 2 o'clock. Get your instructions whether you want to keep the land or not. And if you want, when are you going to clear this amount? Ms. M. Burman, appearing on behalf of the Office of the Deputy Commissioner South Salmara, had placed on record an instruction, a communication issued by the Deputy Commissioner South Salmara to the Commissioner and Secretary to the Government of Assam Irrigation Department, whereby a request was made for the payment of rupees 10 crores 62 lakhs 74,443 to be paid to the petitioner, to be paid to the Patta awardees in respect to LA case number 1/2016-17, 2/2016-17, and 4/2011-12. The said documents are kept on record and marked with the letter X. The legal counsel appearing on behalf of the petitioner submits that the lands of the petitioners have been taken, the possession of the lands of the petitioners have been taken as far back as in the year 2011 and 12, and till date, not a single penny has been paid to the petitioners. This court duly takes note of the materials placed on record and also the well-settled principles of law as held by the Supreme Court, very well-settled principles of law, that the right over the land may not be a fundamental right, but it is still a constitutional right guaranteed under Article 300 of A of the Constitution. Under such circumstances, the respondent authorities cannot take over the land of the petitioner without following the process of law, procedural law, without following the procedure of law. The manner in which the land has been taken from the petitioner by not making payment of the compensation is completely foreign to the land acquisition law proceedings, land acquisition laws. Under such circumstances, this court fixes this matter again on 12th of October 2023 at 2 p.m. The council appearing on Huh? Okay, no problem. We'll ask the commissioner and secretary to be present. No. 12th of October. What is this? You cannot, then you don't have only one council. Okay, on 13th of October 2023 at 2 p.m. It is made clear that if there is no instructions received from on the next date so fixed, the standing council for the irrigation department shall apprise this court as to whether the irrigation department would like to retain the land and if so, as to when the amount of rupees 10 crores 62,74,443 shall be paid to the Deputy Commissioner, South Swalamara Mankasar. Yes, Mr. Roy.
Gold loan, the deposit of his gold order in 25,000. Agriculture, obviously, when there is completely, they issued a notice saying that after the arrangement, when they 1,000 rupees was every month debited to combine SB account. However, during the COVID, they issued the notice saying that the account was short of rupees 20,000. So, they issued, they registered it much later. And then the third notice, they said, we give you 7 days time. Within their 7 days, to take deposit of 28,000. I went and given them the letter saying, please take my money and release my gold. They remained that didn't do anything. After that, I checked my bank account. I found that amount has been debited from somehow it is sold by them without public auction, without giving me a notice. And there was newspaper publication, nothing. I started them under RTI saying, when did you do this? Give me the details of the sale of it. They have not done it. So, I only want that either they should give me back my, it is not sold, give me back my, take my money, give me back my loan, or compensation, or they make an inquiry. That is there for making an inquiry. What has happened to that my gold or not? They have not issued.
They have auctioned your gold and ornaments.
They have not. Though they say, Lord, I specifically asked them, when did you do? Give me the newspaper, give me details of the auction. Did you have all this?
Which company is this?
State Bank.
State Bank is doing such type of thing.
My Lord, this letter that I like to take a lot of the letter. First letter there is at page 15. Finally comes page 15.
What do they say in the affidavit?
They said they have auction it, but no details, nothing of the fact. Give me details, when did it do this?
You had taken a gold loan.
Gold loan only 25,000, my Lord, agriculture gold.
And then
the arrangement was from my SD account every month, 1,000 dollars. But then during lockdown, they said, that's not fall in your account. Please take payment of that amount, will take tax. I went to, when given the money, said, take my money. Give me my, turn back my gold. My wife.
So what was the value of the gold?
The gold would be 1 lakh
Something like.
You have given 1 lakh for getting 25,000.
Hello, yes, you can hear it. They have taken my gold order. I will go.
See?
And one of the kindly see,
Yeah.
the letter, last letter that the account became. It was important to them. And the bank to those two certificate. And the 13(4), section 13(4), they have also.
But do you issue them a notice on the 13(2)? You issued them a notice on the 13(2).
That is their.
Have you issued a notice?
That was not.
Huh?
Not instructed.
No, if without a notice on the 13(2), can you go to 13(4)?
Well, that's a place, it does not mortgage.
Whatever may be, for initiating action under 13(4), you have to proceed 13(2).
Yes, yes.
Have you done that?
Yes. But see, argument, the Oxford was done. Position was already there. 13(2) notice was, in fact, not instructed. However,
No. Without 13(2), how can you go to 13(4)? Tell me, is it possible?
otherwise, that 13(2). it is
Not possible.
Respect- In respect of immovable property, to the secure.
Whatever may be, 13(2) is the basic thing that an opportunity has to be given to him, informing him, look here, you pay this particular amount. Without this thing, otherwise you are going to do whatever as regards the assets which you are holding. Then, without 13(2), how can you have resorted to 13(4)? That is another, that is, we go into sections, rule 6, that is another aspect, I'm not on that. But how can you initiate 13(2), 13(4) with the 13(2)? That is the only thing there.
If you were available for that, the 70, they have not taken because.
No, understood. But 17 is there when you take an action under 13(2), and it is followed by 13(4). But you having not done 13(2), can you go for that? Why will you go for 17 when on the face of it, the act is violated?
And it was not option, no publication, nothing. They made them.
So you want the gold back?
Anything, my money back on gold back now. You were informed about, on Monday, and then the next.
And how much was the amount? How much was the NPA amount?
The amount was 18,000. 18,000 or something. But 32 notice.
It doesn't look nice for a state bank to do this. You instruct your client to do something. I'll have it after vacation, but you instruct your client, this is not done. And after all, it is 18,000, whichever it is, take his 18,000, do whatever you. But without a 13(2), you cannot have a resorted to 13(4).
So far, this point is concerned, you said, I need to give a time.
I'm giving you time, but you get your instruction. This is not how you do. 18,000, bigger amounts you do it, but small amounts, and it's a necklace of the.
That is also not subject to that, exactly rule order. The second sell it also. The amount was in fact, gold cost 60,000 or something.
Huh?
Gold cost about 60,000 or something. Because it's already sold out for rupees 20, 18 to 20,000. I do not know. That part I will take discussion.
You just find out. It's the. The council appearing on behalf of the State Bank of India seeks an accommodation to obtain instructions as to whether to obtain instruction and also to look into it as to whether, without resorting to section 13(2) of the Surface Act, would the State Bank of India resorted to action under 13(4) of the said act? List the matter on 8th of November 2023. But get your instructions.
Audit name,
Market, dynamic. So in the year of 2001, my operation command put my land. And second is the annex of one of the most of tax of 9,001. So that we didn't complete 40 or 50 under the government.
Yes, what are
Because the plan may be open of the process. Within 7 days, approximately, send the final budget as far as anything is said, which I received from the water.
when did you take his land? What? Does it take so much of time? No, we are not concerned about administration. You have taken his land. Why you are not giving it? We have it next week again. Inform the spot. When are you disbursing the amount? Else return back the land. Where's the land? What have you done to the land? So demolish it, give it back to him. Or you will like to have a hut of the on the embankment, isn't it? You want that land back?
Yes, sir.
Return the land. When was the acquisition done? The land was taken?
The year of 2001 and notice out of 2003. And 2003. There is
In the instant case, the instant petition has been filed by the petitioner. Being aggrieved by the inaction on the part of the respondent water resource department. No, this is being taken, it was acquired. Deputy Commissioner, why haven't you taken, paid the money? Being aggrieved by the inaction on the part of the respondent authorities and more particularly the Deputy Commissioner. Which district? Dorong. In taking over the land of the petitioner. In the year 2003.
Yes.
And not making payment of the compensation till date. That is, even after a passage of 20 years. The petitioner hearing is a 74-year-old person who wishes to see who hopes and expects that one day, that someday, that during his lifetime, he would be able to get the compensation. For acquisition or get back the land upon payment of and the payment of the requisition expenses. The council is appearing on behalf of, yes, finance. This is not a case by which one should delay. Does it take so many years?
There's from the acquisition
acquisition was done by resorting to provisions of section 9 of the 64 Act. So, STB acquisition. Here, my lord, the beneficiary department, that is the water resource department, they have not paid the money.
No, that is not, we are not concerned with that. But can you resort to these illegalities? Isn't this absolutely illegal that you have taken their land in 2003 and until now not paid a single penny? And now he has the audacity to say before this court that look here, another 7 days time would be required for the purpose, we sent to the finance department. What is all these things?
On behalf of finance department, I have the instruction that in today we have not received. any-
Obviously you won't, because the water resource department is sleeping over it. No, it can't be. How can it take 20 years for you? If you don't have the money, why you have taken the land? You are going to return the land. I think better off, you return the land back to him and pay the requisition expenses. Because you have a requisition, this will be deemed as a requisition, not an acquisition. You pay him the requisition amount, he will get it. And when are you handing over the possession? I'm taking it up tomorrow at 2 o'clock. When are you handing over the possession of the land to him to inform this? No, Mr. Das, this is not a case by which 20 years does it take? 20 years for you? You are just taking it so lightly. A person's rights is concerned. If you don't have the money, don't take it. Then sell off your buildings out there. But you can't do this. Sell off some of your buildings and pay him. If you don't have the money, sell, don't pay your employees the salary. Pay him. How much is the amount?
84 lakhs.
84 lakhs. Then
And then, given from the deputy commissioner's office, therefore,
first of all, you have to pay. Why you are not paid to the deputy commissioner
given from the deputy commissioner's office, that we have not received.
till now?
No. Just 20 days before only we have received.
Yeah.
That is, so
Why haven't you proceeded? And why did the deputy commissioner take it? The 20 years for sending the report?
we have to concern the right.
They have taken it so lightly. Section 9, by virtue of section 9, you cannot take over the land. You have challenged the acquisition. Have you challenged this acquisition or not? This acquisition needs to be set aside. And you do it de novo, fresh, if you want. This acquisition cannot happen. You have not paid a single penny. You have taken over the possession in this manner, which is a violation of the human rights. It's a human right which has been violated. So under such circumstances, you cannot. And why is the deputy commissioner taking 20 years for submitting of this?
Evaluation has already been done. It is a part of the restriction. Evaluation, land evaluation, everything has been done. It is only on the basis of the evaluation done by the authorities. The restriction I have made a calculation and that am on my own. He has been stating at page 15 of the restriction. So in the 84 lakhs, 40,000,
And what is the estimate given to you by the deputy commissioner? You have it 20 days back, it has been given back to you.
it is a part of the restriction.
No, that he has got it 20 days back. Okay, we'll take it up after some time. It can't happen like this.
44, 45.
What is this matter about?
There was regarding my correction of the and because of I submitted for objection and
Your petition is moved. Dayal Kumar Dey. Your is Dayal Kumar Dey. And this is Ashok Kumar Garodia. Yes, what is your case?
My case was on 10/14, that is the collection of land and for position of being over a plot of land. Notice was issued. I submitted.
Circle officer to cancel phobia or otherwise phobia from giving effect to the notice bearing dated month and or written setting aside the washing the notice bearing numbers when. What is this notice? Let us see.
The first notice that page,
You are hereby informed that as per the instruction issued by you in connection with the application submitted by the applicant seeking demarcation of the land and the report. And the report furnished by the lot mandal after conducting it revealed that you have been holding the land in dark numbers. Hence you are asked to appear before the court with the undersigned along with the document. Then
in page 18, on page 2014,
page 29,
is the second notice, which I have done,
which one?
page 29.
Yeah, that is what I read it.
But the first notice at page 18,
Same date.
page 3, 2014. Page 18, page 3, 2014.
You have not challenged entry.
Well, this is what my case is, that on page 314, a notice was issued. I replied to that. At page 20, I replied to that. Pending as such, they should take another.
So what? So what is your problem? Again, go.
But I
Why should this court interfere with all these things?
have replied to that also.
No, they're very well. Fine.
But I have replied, my lord,
Hmm.
that is at page 21. I have
No,
replied.
no, no. Whatever may be.
Later, before of that notice, my lord,
Yeah, that has been.
That is why, thing is that the petitioner was purchased a land in 1964. He was muted, mutation was done in revenue, but 2009 when resettlement operation started. And one fine morning, when he found that his name was not in the records, then he approached, then he filed a demarcated my land. After that, my lord, this LR stuff goes to this area where his land is actually there. He said, no, your name is deleted from this land. So then again he approached and there is a report. Report says that this parcel land is 205. Now it is a part of 202. That is the minor place here. Now question is that if this is transferred the land, it should be by way of sale or any other mode of transfer. So there is a notice in 10/2014, asking the opposite party to show their documents. That documents. must
Yes,
not
come and
provide-
obtain a stay here.
my lord, at page 14.
So after that, nothing was happened, another notice was given, they have stayed it. Now, from 2012 to 2023, that simple demarcation was not done by this authority. That is why we have.
My lord, what my submission, if he claims that his position is in Tata Material and mine is in 205.
No, my,
He is 205, I am 205. Then my lord, let that be a demarcation.
yes, that's I.
That their claim is also in their reputation.
Your claim is on that number
205.
of pata number?
Pata number 2, earlier needs pata number 2.
No, it's resettlement. What has happened to your pata?
After resettlements, my name was out, I don't know, this is my DAC number, all DAC numbers, they are claiming that this number.
Page
So
50,
now-
now they are paid. Page 50 in reputation.
Now question is that how this
20,
transfer,
71.
documents I want to know, or anything,
7184 of 51, page 50.
and they have access like 8 bigas now.
The week of pandemic declaring as per revenue, the certain price.
So they basically inaction on the part of the survey.
Revenue rate. As per the revenue for the previous system, they will not. The land covered by the.
They are claiming they are the petitioner of 205. And mine is in 206.
No, their sale deed is what?
My lord, I have purchased the land, my lord, you are also.
No, where is your sale deed?
My lord, page 14. This was the property, my lord, after that, governor has said, page 15, page 14.
Huh?
Of WPC number 5449 of 2009.
Wait. Mr. Borua, where is your registered sale deed?
Page 29, to my mother, 205.
This is the translated. Where's the translated?
My love is translated is my love is thinking.
Huh?
Translated cooking, my love is around.
Your lordship is given liberty, I can.
Why liberty?
Actually, when annexing this was page was not in a proper manner, that is why.
So file an additional affidavit then better.
Which means that
No, this is not clear.
Only if you are looking to buy this city.
Okay, what do you want here? The final relief?
Why not demarcation process will be concluded. That's really-
205
both the parties take it.
No, but without his sale deed being brought on record, how can this court decide?
And I result of it.
Taking into account that the sale deed on the basis of which the petitioner in WPC number 7184/2021 claims the right over the land has not been brought on record by the translated copy of the sale deed has not been brought on record. This court grants 4 weeks time to file an affidavit petition.
I can valid this.
What?
Tomorrow I-
For 2021, you have not taken the pain to do so. Why should I?
There is there. In other reports, there is some is there.
The sale deed is there. Your sale deed is there.
Yes, I.
Beginning with it, why haven't you enclosed it?
I understand. After.
I mean, after 4 weeks is after 2.
All right.
46 for the.
Not, give some more time for this, but the living of.
Why?
Already got every time for getting.
You are paying for whom?
Yeah.
Huh?
Yeah.
Why does it take so much of time? This is a matter of 2015. Still, is there a state?
No.
Do we state? No. We state.
Stay on the part that is on the.
Stay has been granted.
So they have challenged the legality and validity of the investigation period of the CBI, challenging the DSPI. W. Kumar. Then judgment and used by.
Then we state because we are not filing it. Why? How can we proceed? If you are on one hand, you are making carrying out any investigation and you are not filing an affidavit for last 8 years. Then what? What recently? On that day you have appeared on 28/8/2023. You sought for time before this court, I remember, and I fixed it on 27/9. Who is Mr. M. Haloi? Yes, this matter came up before this court on that day on 28/8/2023. On that day, you have taken time from me. Then I've asked you to file your affidavit by 27/9/2023. You don't remember, it's a different thing. The CBI may be having a lot of cases, but that doesn't mean we stay the investigation, let it work. What happened? Let us see what has been done. On the trial, we stayed because it cannot go on. We stay, then things will move. Because once we stay the charge sheet and everything, where is it proceeding? Special judge. The instant petition has been filed by the petitioners challenging the FIR/RC number SHG 2010A 0003 dated 13/5/2010, the charge sheet number 11 dated 21/12/2011, pending trial before the court of the special judge CBI Guwahati. The same petition was filed on 9/9/2000, was filed on 2nd of September 2015. And this court, by an order dated 9/9/2015, had issued notice it was further mentioned that the prayer for interim order shall be considered on the returnable date. Thereafter, when the matter was listed again on 2/11/2015, this court had issued rule to 8 years have passed by in spite of issuance of rule by this court that the respondents, that is the Central Bureau of Investigation, have chosen not to file their affidavit. It is further relevant to take note of that on 28/8/2023, the Learned Counsel appearing on behalf of the CBI had further sought for time, and this court had granted time to file the affidavit by 27/9/2023. In spite of the said affidavit has not been filed, and all claims have been made by the Learned Counsel appearing on behalf of the petitioners CBI that the said affidavit is required to be settled by authorities from Delhi, and as such, it would further require more time. It seems that the CBI, the Central Bureau of Investigation, is not interested who is appearing for Nia? It seems that the respondent numbers 1, 2, and 3 are not interested in the instant writ proceedings. And the said aspect would be seen from the conduct of the respondent numbers 1, 2, and 3 in not filing their affidavit, in spite of a rule being issued by this court. It is a well-settled principle that when a rule is being issued, it becomes incumbent upon the respondents to file their affidavit without fail. However, as the respondents concerned have chosen not to file the affidavit, this court, is it pending proceedings?
Yes, sir. Yes, sir.
Now, what has happened to the Supreme Court order? It has stayed. The Supreme Court's order only says that it cannot be investigated. It can be investigated. No, it doesn't say so. Supreme Court order has only stayed this court's order that the CBI had no jurisdiction. No. What is the meaning of a stay? What is the effect of a stay? Has not been set aside. No, not set aside. So judgment still remains. So it has merely been stayed. So if it is merely being stayed, it will only apply in so far as that case is concerned.
However, is the respondent concerned that Susan filed the affidavit list for it?
This court fixes this matter again on 8th of November 2023. This court imposes a cost upon each of the respondents to the tune of rupees 10,000 You are appearing for 4.
No, Lord, I'm looking for respondent number 1 only. Lord.
You are not filing affidavit.
Two extra copies. Other days they have received prior to filing. So, not prior to the, after issuing the notice, brother, I have given the copy I have taken.
Then
Signature is there,
imposes a cost of rupees 10,000 each on each of the respondents to be deposited before the registry of this court on or before the next date. Liberty, a final liberty is being given to the said respondents to file their affidavits on or before the next date, and subject to payment of costs. I'm not concerned. No, I'm putting a cost of rupees 10,000 which has to be paid. I'm not. Our line to deliver. No further adjournments on the question of filing the affidavit shall be entertained on the next day. Yes, you have taken steps. Accordingly, so and so, so and so. So it reveals that fresh steps have been taken upon the respondent numbers 7 to 11 by the respondents, by the petitioner, to list the matter to completion of the steps of service upon the respondent number 7 to 11. 48. None has appeared on behalf of the petitioner on call. It also appears that on earlier occasions also the petitioner had not appeared. Further to that, it is also seen that the petitioner had not taken steps upon the respondent number 7, 8, and 9, despite the directions passed by the Lozima Court dated 17/12/2021, for which the matter has been listed before this court. List the matter again on 16th of October 2023. It is made clear that if the petitioner is not represented and no steps is taken in the meantime, the instant with petition shall be dismissed for non-prosecution. 50. Yes. Why have you not taken steps on respondent number 6? When? When have you taken steps? Taken steps? You have not taken steps against the respondent number 6? Have entered MPL on VR. No AD cards for respondent number 4 and 8 were received back, but none of has entered appearance or 4. Lozima Court directed to take steps upon the respondent number 6 express, but no such steps is received by the section till date. When have you taken? When did you take steps? It is not there. I'm not concerned with whom you are appearing. The learning council appearing on behalf of the petitioner 6 for an accommodation of a week so that he can take fresh steps upon the respondent number 6. Okay. We vacate the interim order. What is the interim order? This quote further. I couldn't leave, huh? This is an application filed for vacating of the interim order dated 12/4/2018, passed in WPC number 2329/2018. Taking into account the above, list the matter in the column of stay vacating on 13th of October 2023. Without, yes.
I know the,
Who has passed the order? What is this review against which or whose order?
the order I ran with the IA. That was 173 of 2022.
Let the GMC allow the members of the petition association to operate a vehicle from the area of Siman in dark number, while allowing the petitioner to so operate necessary verification here is taken. Let the matter be exercised completely. Then what are you asking?
Lordship has seen the order 21/3/22 in earlier number 1273 of 2022. That is the filed in petition 6789 of 2015. That was of
Yes, then what happened after my order passed on 21/3/2022?
for directing the central officer to conduct a detailed survey and measurement of bag number 1772 and March 2020. Lordship, that is the idea, madam, 137.
Then what remains after Justice Medhi's order?
Lordship,
full money. Or circular officer report.
No, understood. After Justice made his orders on 29/2022, whereby the Justice made it clear that they can also measure the other two plots, 1772 and 1774. That was the only order which was passed by Justice.
That is because of a circular officer report.
Yes, that I have seen it, 7/4.
Yes.
Because when the earlier matter came up before this court, I asked you to file an appropriate application. You filed an application and the court passed an order that apart from these two darks, the circular officer would also be permitted to make due measurement of 1772 and 1774. Then after that, what remains?
That I have no knowledge by that.
No, after that, what remains to be reviewed?
No, nothing.
So nothing remains now. In view of this order,
The circular officer must have passed an order.
so everything finished, because that is the only why you sought for a review.
Yes.
Because the circular officer said that although there was a direction to measure 300 and something so and so, but it cannot be measured without measuring 1772 and 1774.
Right.
Now, this permission having been given in IS Civil 1273/2022, nothing survived. So nothing, this review petition needs to be closed in view. Isn't it? That was the only problem which was faced. No, whatever may be, I'm not on that. You see, yes, this has become in view of the order passed on 29/2022 by Justice Mehdi, the review petition stands allowed. Because your review was only to that effect, that the circular officers had come up and said that, look, yeah, I cannot. Taking into consideration that that without measuring these two dots, I cannot measure this. That is the only thing. Mr. J. Roy, the learned senior counsel appearing on behalf of the review applicant submits that in view of the order dated 29/20/2022 passed in IAC 1273/2022 arising out of WPC number 6789/2015. Nothing further remains to be decided in the review petition, in as much as this court, the coordinate bench of this court, by the order dated 29/2022, had permitted the circle officer to carry out the measurements in respect of dark numbers. In respect to dark numbers 337 and 338 by measuring dark number 1772 and 1774. In that view of the matter, the instant review petition therefore stands closed. That is why I remember I gave you that clear to file an IA, because it's not a case of review. I can't review that all. Any interim order, if any, stands vacated.
52.
Another content is between the state party. In that case, with a guardian order on the same week 2023, this that letter along with this letter. That content case number is 624 of 2020, in the same body.
Which is the order you are seeking violation? Which one? Huh? 14/8/2019.
Yes.
What is the work? I am of the opinion that this court, the writ petition can be dissolved with a direction to consider the claim of the petitioner amounting to ₹1 subject to deduction of incomplete works within the scope of remand within 12 months. Issue raised before this court in respect to the claim of interest upon the outstanding amount over the claim amount in respect to AI is granted to meet the appropriate form for the claim of the interest on the AI. Now, what happened?
Now we have this, we take 2 kg below, and this, exponential meter has not returned. Now, since meter is of 21 below, this private, this exponential below, new exponential have to be completed. So.
Why?
The official exponent there below is transferred.
No, first and foremost, don't you have to inform them by filing by issuing a representation to them?
It was done below.
When? Of these new persons?
New persons, because now, your name.
How can you, no, Mr. Goswami, how do you bring somebody? This is a quashing of criminal proceedings. How do you bring it without putting him to notice? Then look here, this is the order, you kindly comply with it. Then only if he doesn't, then will be, because here is the case of willful violation. Then
On the new exponent.
how do you take steps? First, you have to take steps now.
But that is
These-
the order of the Honorable. I have to start the copy.
Then, where are you doing? You have not done it. And what about the service upon them? Neither ID cards nor have answer notice have been received.
In fact,
You are going to take fresh steps
Yes.
upon them, those.
yes.
No, not new, the old ones.
Old one,
Service upon the old ones is not complete.
therefore. What,
If you don't, because you see the matter as of now, I cannot take judicial notice about the other new ones. Unless you bring it to the attention of this court that some else has come. So under such circumstances, what this court can do only is that you have to direct him to take fresh steps. The office note reveals that the service upon the respondents are not complete. The petitioner is directed to take fresh steps upon the respondents by way of registered as well as usual within 3 days, within 7 days from today.
may I pray to give this letter because they are already. a
No.
order.
Unless you show me that order, why should I? And how can the contempt proceedings be listed with this or that? No, nothing doing.
The two similar petitions.
Maybe.
The same part,
Then why you file two petitions?
two different order because.
So all are different course of actions. No.
53. Of like.
It's I can allow going. The substitution 1A, 1B, 1C. Right to sue survives upon the legal representatives of the petitioner. It is negative, you are hidden as the DC, and accordingly, the same are there. Correct the records on the basis of the instinct and also update the same in CIS. I stands allowed. The Econ repetition for the people in view of the answer, this is the matter for admission immediately after the questions. Yes, you got a lovely number in your eye, 3000, tell me. Wow. With getting such a good name and then number and now you want to withdraw. Now tell me, what is this type of letter? Annexure. Are you saying that the office of the senior advocate issues letter that how can it be in the pad of a senior advocate? Not necessary, but how can it be in the pad of somebody else? No. How can it be on the pad of a senior advocate? is a senior advocate appointed, has been appointed by a Wakalatnama, then how can you use his bed? Tell me. Permissible? Yes, we have a senior advocate sitting out here. Yes. Tell me, is this permissible? Kindly see. Is this permissible? That I am withdrawing Wakalatnama on a senior advocate's bed? Tell me, why shouldn't I refer this now to the Bar Council? As well as to the Chief Justice. It violates the ethics of a senior advocate. You can't, under no circumstances you can. No, there is no example. Because the senior advocate cannot have a connection with the client. Then, an instruction from the senior advocate. Are you telling me that the senior advocate has instructed you to withdraw the Wakalatnama? Is this how the things work? It has to be upon your instructions that senior advocate submits. Or is it the other way around in this office? Yes. The Learned Counsel appearing on behalf of the Learned Counsel submits that he would like to withdraw the instant application and submit a fresh application. I stands closed. Next time, don't do this. It has a far-reaching consequences. Yes. Hmm. What is this matter about? No? IAS in it. Why the matter has come up? 50? This is? 65 is the last. It's an admission. No affidavit has been received. No reply received. Affidavit has been received by the section. Yes, any affidavit filed by government? Affidavit filed.
I am appearing on behalf of respondent number 1 to 6 LICI. That's why I filed
456? 1, 2, 3, 4, 5, 6. Okay, and why they are mentioning there's no affidavit filed? What is this type of instruction? Affidavit is to be filed by respond number 7 and 8 by 310. Who is respond number 7 and 8? You don't want to file it. No, don't file it. Who has asked you? We have given you the liberty. Don't file it. We will record that you don't want to file it. The Learned Counsel appearing on behalf of the respond number 7 and 8 submits that they would not like to file 7. 8, where does 8 come in?
8 by
Huh? 2 weeks time may be granted to put order the house. I hoisting. We could change for a 9. So the order dated is to carry out the correct treatment notification for correction of the post title before the person to file the registering take the same this year. However, there is no such claim to be received by the section dealing. Hence could not be updated. Could not be updated the same in the slides. Directed to like it henceforth all amendments to the post title shall be done in the concerned section. The registry unless specifically directed by the group of the before the that would be system. Don't people always all this Register General, whoever it is, whoever issued this. But কোনে করেছে? What does he mean to say on this? Register Judicial. এটা কোর্টে অর্ডার দিয়েছে, কোর্টে অর্ডার দিয়েছে, how do they say this? Where is it mentioned that the one has to file a separate memo here for correction of the concerning one? Amended post title liability কেতিয়া পাবছে? In continuation of the registry's notification numbers, it is hereby directed henceforth all amendments to the post title, pleadings, etc. shall be done in the concerned section of the registry, unless specifically directed by the court to do the same before the register judicial. কি বেসিসে কথা পাস করছি? This court, দেখো, how can that be? This court, by an order dated 11/9/2023, had allowed the interlocutory application being IAC number 2452/2023, whereby this court permitted the said application, thereby impleading the mother-in-law of the petitioner, that is Srimati Anju Borua, wife of Sri Jatin Chandra Borua, resident of Debeswar Sankakoti Path, Old Amalapathi, PO and PS Sibsagar, in the district of Sibsagar, Assam, PIN 785640 as the respondent number 8 to the petition. This court, by the said order, further directed the registry to make necessary correction in the records, as well as also upload the same in the CIS system. This order has been passed by this court under Article 226 of the, in exercise of the powers under Article 226 of the Constitution. The said order. However, this court takes note of the office note dated 6/10/2023, wherein it has been mentioned that as in the instant case, no bracket amended post title have been received by the section till date, the same could not be updated in the CIS. This court have also perused the notification number 79 dated 19/6/2023, wherein it has been mentioned that all the amendments to the cause title pleadings, etc., shall be done in the concerned section of the registry. Under such circumstances, this court sees no reason as to why the registry cannot make necessary changes on the basis of the order passed by this court, on the basis of a judicial order passed by this court on 11/9/2023. Further to that, it is also not seen this court further directs the registered judicial to submit a report wherein there is a mention of submitting an amended cause title. This court have duly taken note of the office note dated 6/10/2023, wherein a reference was made to the notification number 79 dated 19/6/2023. A perusal of the said notification reveals that in case amendment in the cause title is under the orders passed by this court, filing of amended cause title would suffice. In the instant case, in the interlocutory application being ISC number 2452/2023, this court, by an order dated 11/9/2023, had permitted the impleadment of the respondent number 8. The office note dated 6/10/2023 shows that the amended cause title have not, however, been filed. The learned counsel for the petitioner submits that the said amended cause title will be filed within 3 days. Mr. J. Roy, the learned counsel appearing on behalf of the respondent number 7 and 8, submits that he would not like to file any reply. Would submit a reply with a cost of ₹10,000 to be paid. Huh? No, you have taken earlier, na? Notice was issued on 10/3/2023.
No, but the implement was for that time, they finally then we take.
Would submit their reply affidavit in opposition within 3 weeks from today. Okay. List the matter again on 15th of November 2023. The affidavit be filed by 6th of November, 7th, 8th of November 2023 by the respondent number 7 and 8 without failing. The interim order passed earlier shall continue till the disposal of the petition.
So one is, so
I've seen it.
Pending item 43.
Yes,
Because the that's 13,000.
Hmm?
86, that's 13,000.
then when are you paying it?
And they will be sending the same proposal.
Why haven't you sent it till now? He says 84, you say 86.
86, that's 13,000. That is the revised.
So 2,30,000 has it gone above? Whose money is that?
Individual amount of. Then line account is, and the all of that, no, someone is from foreign.
No, no, he says from, for only the petition.
Only the piece.
So you say-
The total sanction amount is 2,796,231. And the amount of the.
Sanctioned by whom?
No, the land acquisition, compensation amount. Is the proposal which we have received from the deputy commissioner. The total amount is 2,796,231. And in the name of the petitioner is 86,13,000.
When are you sending it?
But we will send within 7 days to the finance department.
And finance department, how much time? We'll have it again day after. Where you send the proposal. Day by day after. If you don't send it, you return the land. This can't, because this is not a manner in which you can take it. No, it can't happen like this. Look, the incident with petition has been filed by a 74-year-old petition. Being aggrieved by the inaction on the part of the being aggrieved by the actions of the respondent authorities in taking over the plot of land belonging to the petitioner. And not paying the compensation since 2003. Mr. R.M. Das, appearing on behalf of the Water Resource Department, submits that the Deputy Commissioner, Dorong, had submitted the proposal only 20 days from today, before the Water Resource Department. And within 7 days from today, the same proposal shall be sent to the Finance Department. Mr. Arbo Pujari, appearing on behalf of the Finance Department, submits that the same proposal has to be considered and it will take some time. Next. This is a case where the acquisition proceedings was initiated in the year 2001. By taking recourse to Section 9, on urgent basis, the possession was taken. Although Section 9, by taking recourse to Section 9 of the Assam Acquisition and Requisition Act 1964, possession of the land was taken from the petitioner. in the year 2003. Till date, not a single penny has been paid. No award has been passed. Has the award been passed? No award.
First estimate of the as per 2013, that it was not earlier notified. That stand is taken in the additional application by the commissioner. Because
So have you passed the award or not? Award has been. Yeah, award has. A petitioner who's the right over the yeah, not a single penny has been paid. The right to use and possess the land, the right to use, comma, possess and control over the land have been taken over by the respondent authorities. And for the last 20 years, not a single penny has been paid. And have been taken without payment of any amount. A perusal of section 11 of the Assam Land Acquisition and Requisition Act 1964 stipulates that the compensation would be paid in terms with the Land Acquisition Act 1894. Subsequently, in view of the notification which have been issued by the Revenue and Disaster Management of the Government of Assam, it has been mentioned that the compensation has to be paid in terms with the Assam Right to Fair Compensation into Lumbar Namtudi 2013. In both the Land Acquisition Act 1894 as well as the Right to Fair Compensation Act 2013, the interest to be paid is 9% from the date of handing over of taking over a possession for the first year, and thereafter at the rate of 15% after completion of the first year. It is not known as to whether the said interest element has been calculated while making the proposal to the respondents by the Deputy Commissioner. But taking into account that the interest amount would be paid for a period of 20 years, the said amount would definitely be a very huge amount. Taking into account, in view of there being an acquisition of how much area? 4 bighas, 15 lectures of land. And what was the market value? Huh? And the market value was assessed at rupees 20 lakhs per bigha. Now the question arises as to whether, and the question arises as to who would be responsible for the purpose of payment of responsible on account of the delayed payment of the compensation. Would it be the Deputy Commissioner, Dorong, who had only, as per Mr. R.M. Das, the Learned Standing Counsel for the Water Resource Department, provided the estimated amount, the revised estimate, 20 days from today? Or is it the Water Resource Department who would be liable, taking into account that not a single penny had been paid by them, in spite of the acquisition made as far back as in the year 2003? This court fixes this matter again on 16th of October 2023 at the top of the list. On which date Mr. R.M. Das, the Learned Counsel for the Water Resource Department, shall apprise this court as to whether the proposal has been submitted to the Finance Department. This court would pass further consequential orders, thereby consequential on the next day as regards on the next stage, on the basis of the said instructions. Huh? No, we can have it on a Saturday if you want to come. I'll have it by video conference.
Number 32,
18, the last day you want to again go away. 18. Why? Huh? Finance, where is the taxation department? You have no, why are you making the finance apart? Finance will be Mr. Borpugari. You want him. Where's the taxation department? Finance and taxation are different. So then this application has been wrongly filed. Withdrawn with liberty to file afresh. The learned counsel appearing on behalf of the applicant submits that as the application has been, as the correct department have not been as the application, in that as in the application, the correct departments have not been mentioned. He would like to withdraw the instant application with the liberty to file again by seeking, by incorporating the correct department. I stands closed on withdrawal with liberty granted. Now this petition is this.
Number 32, my lord,
No, 31,
31.
30. Now tell me, without the finance and taxation department, why should we stay the VAT amount? We'll stay the excise amount, but not the VAT amount. VAT amount you pay. We don't have the finance department. I'm not going to, you have not made it. Last time I allowed you. He is affected. Because of you, he has not got it. The amount has been lying out there, isn't it? These amounts are very huge amounts. The stay is a huge amount. And here you have not filed an affidavit also.
They have not had it.
Oh, we'll take up for matter for disposal today. You have not filed it. Cost. This court had, by an order dated 11/9/2023, permitted the respondents to file their affidavits. However, no affidavit has been filed till date. Mr. D. Gogoi, appearing on D. Gogoi, the learned standing counsel, Excise Department, seeks for a further accommodation. Taking into account the matter, this court further grants an accommodation subject to imposition of a cost of rupees 10,000 to be paid by the Commissioner and Secretary Commissioner by the Excise Department before the registry of this court on or before the next date. The repetition is fixed on 30/11/2023 to be deposited by the respondent Excise Department. Let the repetition be fixed. The repetition is directed to be fixed on 30/11/2023. The affidavit be filed by 23/11/2023. The said affidavit shall only be accepted upon deposit of the said cost of rupees 10,000 as directed. In time order passed earlier, will continue. Can't help it. Cost is there in the 15. You have been happy enough not to get any amount of them.
31.
No affidavit filed. No affidavit. 31, no affidavit. 2901/2021. When? Oh, you affidavit filed? Is not on record. You have filed reply? You are not going to file it. 10,000. The Mr. D. Gogoi, appearing on behalf of the Excise Department, submits that the affidavit has been filed by the Excise Department. However, the said affidavit is not on record. The registry shall bring on record the said affidavit. list the matter again on 30/11/2023. Mr. J. Roy, the learned counsel appearing on behalf of the petitioner, submits that the petitioner do not intend to file any affidavit in reply. List accordingly.
32.
Somebody died.
Substitution act.
You have filed. No. The instant application has been filed by the applicant, who is the wife of the petitioner, who expired on 25/2/2023. Taking into account that the applicant, the right to sue survives upon the applicant pursuant to the death of the petitioner, the instant application is allowed, thereby substituting the applicant as the petitioner. The applicant further is directed to file an amended cost type. On the basis of the same, the registry shall update the same in the records as well as also in the CIS. IS stands accordingly allowed. In this matter, you are filing affidavit. You have not filed
We have stated this.
cost. There is an order passed,
5 minutes this week.
cost,
I had a cost.
another 10,000. These will help you people. These will all go. I'll pass an order to be sent to the advocates. What is that?
No, we costly start this week as well as start.
Huh?
My senior will get it well, he'll NCS well, because it's a costly. 10,000 is enough for the well again. Because
No, we'll do one thing.
the next metro also will let it not fight.
No, we'll do one thing. We'll make it.
Cumulative 30 well, but
No, we'll make it 3,350 for each.
then. If that well,
Yes, 3,350. It will be 10,000.
will cover for all three days, 5 months.
Yeah, আগৰ এইটো যে আছে কষ্টটো লগোৱা আছে এইটো আগৰটো 10,000 গুচাই দিব 3,350 এইটোতো 3,350 আৰু এটা নেক্সট এটা আছে
That's not that.
33.
এইটো 3,350 একে